Good morning, everybody coming in. We are going to be doing Trump v. Slaughter here in about 10 or so minutes. They should be getting started. I'll go through a little bit of background. I do have a video in my bio, but the Trump v. Slaughter case involves these sort of Trump firings that have been going on. Now, this one is specific to FTC Commissioner Rebecca Slaughter. Now, certain things to know about this. FTC commissioners are appointed by presidents. It's kind of gated out so that there can't be like this unequal amount of like partisan influence on things. Now, Rebecca Slaughter, she was reappointed by Joe Biden. I can't remember the year right now, so I apologize and please forgive me on that. But since it's 7 years, I would say that would be 2022 because she's up in 2029. So anyway, she was reappointed by Joe Biden. Well, Trump gets into office and he is like, I don't want you here anymore. Our agenda does not align. So you got to go. Now, with FTC commissioners, the FTC Act of 1914 put in these sort of guardrails that they could only be fired for, I know it's malfeasance, non-efficiency, and there's one other, and I can't right now. I do have a video. It's about 3 minutes explaining the extensive background on this case. Yes, this is being heard today, Lawless. So anyway, he referenced none of these things when he shit-canned her, basically. So she took it to court. And then the district court, and then it was reaffirmed by, it's either the DC Circuit or the Second Circuit. Right now, my mind is drawing a blank. I only got like 3 hours of sleep last night, so I really, really apologize. But anyway, basically, he had to put her back. He didn't do what he was supposed to do under the FTC Act. And she, the Trump admin was like, no, we don't. They appealed to the Supreme Court. And so the Supreme Court is going to hear this today. The Supreme Court has already looked at this before. Back in 1935, FDR tried this exact same shit. He tried to get the person to resign, and then he didn't even offer a reason. He wasn't even like, our agendas don't align. He just shit-canned them. So, Humphrey, that's the Humphrey executor precedent, Humphrey passed away. And then his estate said, no, he was still working for you. You owe us that salary. So, they take a look at this, and, the Supreme Court said this act is the language is unambiguous. Like, you have to do these things and you didn't do it. They also take a look at whether it violates separations of powers. And they were like, just because you have the power to appoint them doesn't mean you have some unilateral ability to dismiss them, because they were created by the legislature. They are a branch that was created by Congress. So we're going to be looking at this today. Trump arguments, John Sauer, aka RFK Voice, will be arguing this. Trump admin is saying, well, I don't know if Humphrey's executor is still good law because the FTC has a lot more executive powers now. And even if it is still like, it violates these separations of powers for the president. So we're going to be looking at this. It should be starting right about 9 o'clock. I came on a little bit early to do some explanation. If you have questions, put them in the comments now. It's going to be harder to answer while this is going. I know Law is very, very busy this morning, but he did say he would try to stop by. So we may get to hear from him as well. But if anybody has any questions, this is a big case. This deals a lot with some of the firings that are going on right now. They'll also be addressing another case. I want to say it's Cook. I want to say that's the name, about one of his firings. But what's interesting to know is a lot of these firings are quite similar. And that's where it gets even more problematic, is like, where does Trump have the power within the executive to like summarily dismiss people? So please, if you have questions, drop them in the comments. I'll start this as soon as 9 o'clock hits. Sometimes they start a little late. It just depends. So, but if you are interested in whether Trump has basically this sort of unitary executive where he can just do whatever the hell he wants, damn the law that's on the books, we're going to find out. Where does the president have the power? Because this will be the law of the land for decades. So the president has a lot of purview over the executive already. However, because the FTC was like, it's sort of this independent creation by the legislature with the presidential power of appointment, but not the overarching presidential power of dismissal. They have to show cause for why they dismiss these people, unlike some of the other executive positions. And that's why this is a bit more tenuous. I mean, Humphrey's executor, like the FTC Act was 1914. This was reviewed in 1935. So we're looking 90-ish years of precedent. So we're going to see where this goes. I'm saying this isn't about Trump. This is about our constitutional president yeah, I agree. So this is like, this deals a lot with this sort of like concept that the Trump admin is like really, really fond of, which is the unitary executive, where the president just has a very broad overarching power over, oh, thank you, Googs, over everything in the executive branch. Yes and no, that's not exactly how that works. Just because you have an overarching power does not mean that you don't have to follow guidelines that may have been set in place. It's very much sort of, they're damned if they do, damned if they don't. I don't know where they're going to go with this. I want to say, particularly with the FTC being involved and this being a specific act and created by the legislature, this is going to answer a lot of questions down the line about any firings he may do in the future. They're going to review another case at some point with, I believe it's Cook, that also deals with a firing. So we'll know a lot more after that. Oh, let me start seeing if they're going. Give me one sec. Well, it's circling right now, so let's see where they are. See where they go. Hold on, let me refresh my. I apologize, guys. I try to keep talking with y'all, but okay, they're on. So we're just waiting for them to actually introduce and start. But yeah, so just this is a banger case. I want to know, like, I really want to know where they're going to go with this. And I mean, I am tempted to think that the sort of originalists and textualists on the court are going to have a lot of problem with not only the history of how the FTC was created, but also the very specific language of the FTC Act. And it's saying that you have to show cause. It's one of three reasons. It's malfeasance, non-efficiency, and I wrote it down. Give me just 1 second. Sorry, I have a lot of notes. So inefficiency, neglect of duty, or malfeasance. He didn't name any of those. He just said, yeah, my priorities and your priorities aren't the same priorities. So that's all that happens. That's not showing cause per the FTC Act. So I think I really want to know if they're going to hold firm in originalism. The only thing I think Trump is offering to sort of, to sort of speed this along is this idea that, well, what the FTC has evolved into they've undertaken more executive authority, like their ability to pursue people who may violate it and things like that. So that's where it becomes a little bit more sticky. Listen, you like Trump, you hate Trump, I don't care. Like, this isn't a political act. This is literally about the case. I'm not working against anybody's cause to fire. I want to know what the Supreme Court thinks about it. We'll know a little bit more after these arguments. I think the biggest people to watch are going to be Roberts, Barrett, and I'm going to call Gorsuch on this. Not Kavanaugh, because sometimes Kavanaugh will ride with the justice, but he's a bit more inclined for the unitary executive. But I'm going to go Gorsuch, Roberts, Barrett. Those are the people to be watching in this case. And as soon as it starts, it'll start playing. Sometimes it says 9, but sometimes I don't get off until about 9:05. So yeah, they may not, Adam. Like, I'm inclined to think that there are going to be some justices that have been more fond of sort of executive power, but there have been some that have given pause. I really honestly don't know what way they're going to go with this. Like I said, the justices to watch I'm calling right now is going to be Roberts, Barrett, and Gorsuch. Sometimes I'll go with Kavanaugh, sometimes I'll go with Gorsuch, but I think Gorsuch is very, very, very much one to watch on this. He's quite fond of, well, what does the text say? I know. Yeah. Yeah, Gorsuch is different than Kavanaugh, and he's very fond of this sort of probing that I like to see in these cases about, well, what does it say? Does it mean what it says? Does it say what it means? So, why isn't this a non-just political question? I'm just saying this is not a political live. I'm literally just talking about the case right now. I have my own political leanings. I don't mind if I want to talk politics in the chat. I'm just not discussing this in a political nature. I'm not sure. Oh, come on. And who is in here being all loud in the Discord? RJ's Discord, god damn it, y'all shushes. Hold on, I'll turn my notifications off for that one. That one's usually popping off. But anyway, yeah. So I don't know. Let me refresh real quick and see what we got. Taking their sweet time with this shit. Make sure my volume's turned all the way up. Yep, I'm good. I mean the legal analysis portion.
We will hear argument this morning in case 25332, Trump versus Slaughter. General Sauer.
Mr. Chief Justice, and may it please the court. In SELA law, this court held that the president's power to remove and thus supervise those who wield executive power on his behalf follows from the text of Article 2, was settled by the first Congress. This is the best argument they're going to make. Has been confirmed by precedent, including at least 9 decisions of this court from ex parte Hennon through Trump against United States. Humphrey's executor stands as an indefensible outlier.
Not John Sauer, but he sounds like RFK.
Holding that federal agencies can exercise quasi-legislative and quasi-judicial powers that form no part of the executive power has not withstood the test of time. That holding was gutted and refurbished in Morrison, but this court correctly rejected the refurbished version as providing an amorphous test with no limiting principle. Respondent now proposes a third update to Humphreys, which this court has already rejected as making no logical or constitutional sense. Y'all can tap the screen, please. It helps a lot with the live. I appreciate it so much. Humphreys must be overruled. It has become a decaying husk with bold and particularly dangerous pretensions. It was grievously wrong when decided, and cases from Morrison to Trump have thoroughly eroded its foundations. Ooh. The court has repudiated Humphrey's reasoning and confined it to its facts, but it continues to generate confusion in the lower courts, and it continues to tempt Congress to erect at the heart of our government a headless fourth branch, insulated from political accountability and democratic control. As Justice Thomas wrote in Selah Law, Humphreys poses a direct threat to our constitutional structure and, as a result, the liberty of the American people. And as Selah Law held, the modern expansion of the federal bureaucracy sharpens the court's duty to ensure that the executive branch is overseen by a president accountable to the people. I welcome the court's questions.
General Sauer, could you give us one example of a permissible restriction on the authority to remove a principal officer?
We don't believe there are permissible restrictions on principal officers of the United States who exercise the executive power. Now, there may be separate issues relating to particular historical pedigrees.
In this case, in a multi-body.
One thing I will say for Sauer, sorry, I have something on my hand.
FTC.
One thing I will say for Sauer is he will circle the wagons and he will not deviate or make a concession.
The president's power to remove officers wielding the executive power is conclusive and preclusive.
How far do you go with that? Can it be arbitrary, completely arbitrary?
It is conclusive and preclusive, so any review of arguably bad reasons for the president to remove an executive officer
conclusive
would be
and
subject to the political process.
preclusive. It's a throwback to the immunity ruling.
It's certainly not subject to statutes regulating that.
I think there are a lot of agencies in the federal government where it's hard to parse whether it's an executive function they're engaged in or a legislative function. We obviously have the Perlmutter case that they're holding where you're dealing with the Library of Congress, which half of it's a library, half of it's things like the copyright.
I think that's
what
Alito.
What are we supposed to do with that, if you're correct?
I get Alito and Gorsuch's voice mixed up, so I already apologize.
I think very aptly stated that the vast and varied nature of the federal government is a reason not to make general pronouncements on issues that haven't been briefed and argued. There are certainly situations where there are tough line drawing problems.
Roberts kind of has more of an old man voice, so it could be Roberts.
But by and large, the
man voices
sort of
run together for me.
That goes from Morrison to FCC against Arlington and to Selah Law recognizes that these multi-member agencies that are exercising what this court has repeatedly recognized as quintessential executive powers, like the FTC, rulemaking, adjudication, investigation, seeking of civil enforcement power, litigation, seeking civil enforcement powers, and
conclusive and preclusive.
Those are not close cases.
Yeah, I mean, I appreciate your point about not deciding cases that aren't before us, and I meant the Perlmutter case as an example. But I'm not sure you answered the question. Is this a severance issue? So the agency is okay, so long as half of it survives in one branch and half in the other, and if so, who gets to decide that?
That's a good question.
For the vast majority of these agencies, I think, as Selah Law pointed out, there's maybe about 24 executive agencies that are multi-member structure and have removal authority. I think the logic of this court adopted it for severability in Free Enterprise Fund and Selah Law, and Collins indicates that in the vast majority of cases there would be an excision just of the removal authority. Now, if there are agencies that kind of straddle the line between legislative and executive, that might present part or severability concepts.
Why is that severability the issue?
Sotomayor?
Meaning, if you think they're wielding power that is inappropriate, why don't we sever that power?
I think those very arguments...
Instead of the removal power.
Well, for example, consider an agency like the FTC, which is before the court. Virtually all of its powers, I can't think of a power that exercises...
But most of those powers were part of Humphreys. This court, even in Sheila Law, and all of the cases you've mentioned since, have said that Humphreys is controlling law. You're asking us to overturn a case that has been around for nearly 100 years, correct?
90 years, I believe.
About 90.
What other cases have we overturned that have had a pedigree of 100 years?
Besides against Neff was overruled by Schaefer against Heitner on its 100th birthday.
That was an economic case. What other case?
For example, Erie overruled a Swifty Tyson 96 years later. Those are two examples. There's at least 13 or...
But Roe didn't have the 100 years of precedent. Sorry, I missed that part of it.
For over 100 years,
She's
actually since 1887,
asking
we've
a-
had multi-member boards, and
I'll get into
that's
it.
the
Just
entire
remind me at the
government
end of the
structure.
live.
The distortion of the structure of government, respectfully, that Humphrey, the philosophy of Humphrey.
Aren't you asking us to distort it a different way?
Yep.
I think we're
Neither
asking.
the king, nor parliament, nor prime ministers, England at the time of the founding, ever had a unqualified removal power. You're asking us to say that at a time, the founding, when the Constitution doesn't speak about this at all, where there was robust debate over this issue among
sorry,
legal
guys.
scholars at the time, that we ourselves has said repeatedly in Humphreys and other cases, Wiener, even in Myers, that
Not Wiener. Sorry. That one
those
got me.
cases you mentioned did not establish this absolute power of the president. You're asking us to destroy the structure of government and to take away from Congress its ability to protect.
Well,
its
she's not
idea
wrong.
that
We talked about this at the beginning.
Government is better structured with
The
some
FTC of
agencies
1914
that are
is
independent.
very specific on how we
I think we're
remove
asking the
people.
court to return to the dominant line of authority that started in Ex parte Henin in 1839, when this court said that it's a settled and well understood construction of the Constitution that the president alone can remove executive officials. That was reaffirmed in Parsons, for example, where it described it as settled beyond the power of alteration. Again, in Shurtleff, similar language.
But even when they
Myers says the
re-examined
same
this
thing, Free
in
Enterprise
Myers,
Fund, Collins, seal
because
law,
of
Trump against the United States.
the
And
way
even
that it was created,
Humphrey's
it's
executor
both
itself
legislative
paid lip
and
service to this principle.
it
Humphreys
has-
described this power as unrestricted and illimitable. And in order to get out of that rule, which the court has recognized in those 9 decisions, is going back
You
to
still haven't
1789.
answered my question. Where else have we so fundamentally altered the structure of government?
I think what the fundamental alteration of the structure of the government was ushered in by Humphreys, and then the Congress kind of took Humphreys and ran with it in the building of the monstrous administrative state and the proliferation of independent agencies that are insulated from
Independent
democratic
agencies
control.
have been around since the founding, the sinking fund, the War Commission. We've had independent agencies throughout our history.
That's
So
true.
this is not a modern contrivance.
We disagree with that, as in our brief, we disagree with that characterization of those agencies. The Sinking Fund Commission, for example, was composed of 3 officers who are cabinet
And we have an
secretaries.
amicus that
clearly
shows
removable.
us how the president's will could have been thwarted by that structure. We have an
Y'all
amicus
so
brief that
much. If y'all
shows
can
us
just
how
tap
that
it helps the live
the
so much.
president's will by that structure could have been thwarted.
These kinds of historical
Oh, thank
examples,
you,
I think,
Bruce.
have been considered in this court's cases from Free Enterprise Fund and seal law and so forth.
So what do we
There's
do
been a lively
with
debate
Morrison?
about that, and the court
What do
has
we
come.
do with Morrison and Wiener and Perkins?
Well, Morrison, for example, I think is a really critical precedent here, because what Morrison did is it repudiated the entire logic that supported the holding of Humphrey's executor. It repudiated correctly the idea that there are these quasi-judicial and quasi-legislative powers that are outside the executive power, and yet they're wandering around the executive
Yet
branch.
you
and not in-
answered the Chief Justice by saying that maybe we just need,
Oh,
to
was
look at
Roberts.
each agency
He was sounding good
individually.
today, Bree.
so we can't leave that area. By the way,
Good
your
call.
logic, you're putting at risk. By this, you're saying there's uncertainty. I think the uncertainty in the lower courts was not over Humphrey's executor. It has been over the court's most recent decisions, not because of Humphrey's executor. But you're putting at risk the independence of the tax court, of the federal claims court, Article I
Sotomayor
courts.
is not having
You're putting
his
at
shit
risk
today.
the
For
civil
real,
service.
for real.
I don't see how your logic could be limited.
As to the non-Article 3 courts, we haven't challenged the removal restriction as
Not
the
yet.
non-Article 3 court
Not-
in this
not
case.
yet. Not yet.
And we recognize that there are some line-drawing issues as to those that came up in cases like Freitag and Ortiz. Again, those aren't presented here. Those aren't briefed here. and
Not
court
yet.
could
There's
address-
a difference, I suppose, between Humphreys and Weiner, right? In terms of whether you overrule one or overrule the other, in terms of the consequences with respect to modern agencies.
Humphreys even reflected on Myers.
Commission in Weiner, if you think that that's more like something like the Court of Appeals or the Armed Forces or the Tax Court or all those others, strikes me that Humphreys may be the issue, and that doesn't mean that Weiner falls with it or that the other agencies fall with it as well.
The piece of, we have a footnote about this in our brief, footnote 1, and we invite the court to overrule Weiner as well. Part of Weiner we think has been overruled by Braidwood, which is Weiner, interpreted.
I'm sorry, if he says Weiner one more time.
Statute, and that contradicts until Braidwood. The other,
it was like Ketanji Brown Jackson kept saying thrust the other day. That's the level I'm at right now.
Seems to have a very firm hold on Congress and a firm hold on the lower courts, and that's why there's been a proliferation of litigation.
Well, there's one thing about, and I'll be brief, there's one thing about philosophy and there's another thing about holdings. Certainly the holdings of Humphrey's executor doesn't necessarily support Weiner to its fullest extent.
We agree with that.
General Sauer, can I ask you about the Federal Reserve? The other side says that your position would undermine the independence of the Federal Reserve, and they have concerns about that, and I share those concerns.
Got to support
so
Weiner to its fullest
distinguish
extent.
The Federal Reserve from agencies such as the Federal Trade Commission?
We recognize and acknowledge what this court said in the Wilcox-Harris stay opinion, which is that the Federal Reserve is a quasi-private, uniquely structured entity that follows a distinct historical tradition of the first and second banks of the United States. There's two adjectives there, an adjective and an adverb, unique and distinct. The Federal Reserve has been described as sui generis. Any issues of removal restrictions as a member of the Federal Reserve would raise their own set of unique, distinct issues, as this court said in Wilcox against Harris. We have not challenged those, either in this case or any other case.
Thank you all so much for the likes and the follows. Y'all are so amazing. I'm glad you're hanging out with me.
I think the question that these questions go to, right, is if you take your logic at face value, it seems to include a great many things. If I were to say, your fundamental proposition in your briefs is that the vesting clause, how many times do you say in your brief, gives the executive power, all of it, to the president? And so if you believe that, the fact that you can say, well, this has a history and that has a tradition, doesn't much go to the rationale that you are asking this court to accept.
Wilcox is
so
a 2025.
Once you're down this road, it's a little bit hard to see how you stop. And I think that that's one question. I mean, there's another question about whether you should start at all.
Stay on orders
of
reappointment.
Is if you
I was
accept
struggling
that proposition, which is the fundamental proposition of your brief, it does not seem as though there's a stopping point.
Yeah, I think it's a proposition of our brief, but those are obviously quotes from these courts' opinions. So it isn't that we have gone down this road. I think the court has been down this road. The country has been down this road since the decision of 1789. Again, Ex parte Hennon describes this as settled beyond doubt.
1789.
Again, Parsons, which anticipates all the analysis of Myers, says the very same thing. This is beyond question that there's this removal power. And keep in mind, that's 1897. It's well after the bitter interbranch disputes about the Tenure of Office Act. It's after Congress started engaging this proliferation of restrictions on the removal of inferior officers.
Well, let me ask you how you would justify and how you would justify consistent with the proposition that all executive power is vested in the president.
This is John Sauer, not RFK,
with,
though they
Article
do
1
sound
courts.
very similar.
How would you justify keeping those courts?
Well, those courts, the determination would have to be made on a court-by-court basis, so to speak, as to whether or not they're engaging in the executive power. There may be tough line-drawing questions there.
I mean, I thought that one of the things that we've said, again, in many, many cases, is that even though they're engaging in adjudicative functions, they have to be executive by their nature.
There's a dispute about this, I think, basically lurking beneath the surface in the discussions in Ortiz. If they are indeed exercising executive functions, then the logic of this logic would apply.
Go ahead, please. No, go ahead.
I'll go.
Nice.
Is it a possibility, let's say you have an agency that is I don't know, pick a number, 85% is judicial.
I want to say this is Gorsuch.
Some of the judicial entities that have been talked
Or
about.
It may be
briefs.
Robert.
A
Shit,
smaller
I don't know.
percentage is
I'm
some
having
executive
issues with the
function that
voices
they
this
do,
morning.
whether it's issuing rules or whatever. Is there a principle that you would sever out the smaller little tail on the dog and allow the
I have to
judicial
hear him a little
functions
bit
to
before I can be like,
go,
this
go on?
is.
Quite possibly, that would be I think a unique severability question that would be distinct from the merits. So if there was an agency that kind of straddles the line between two branches, and that may raise a different severability question. But for the mine run of these multi-member executive agencies, they're clearly exercising
the
executive
FTC
power. They're doing stuff that the NLRB
does
that
raise
the
the
MSPB
question
does.
of where does it lie?
So you are here saying the
This is
NLRB
Kagan
goes
again.
down, the MSPB goes down, notwithstanding that they do all their work, or almost all their work, in judicial type proceedings.
I wouldn't say goes down. I would say they were restored.
They are quite, sorry, I'm going to pause it just real quick. They are quite literally asking them to not look at the language of the 1914 FTC Act put in place and just do whatever because. This is very important as you hear the textualists and originalists on this court. I want you to hear what they're asking.
Or to democratic accountability and the constitutional structure, but we have contended on
the
the
current versions of those agencies goes down.
We have challenged those in this court, NLRB and MSPB, and there are others. And this court in Sailor Law, I mean, there's various lists out there.
How about inferior officers?
We haven't challenged any restrictions on inferior officers.
Why wouldn't that also have to go?
That would certainly, restrictions on inferior officers of the United States would be problematic because, of course, Myers involved in inferior officer.
Right.
The logic of Myers extends to inferior officers.
And obviously, there are all kinds of inferior officers wielding executive power all over the place, yeah?
There are many.
Yeah, so it seems as though executive officers. How about employees?
Again, we haven't challenged the restrictions on.
I know you haven't challenged it. It's really, the question is, where does this lead? What does it take you to, given what your primary rationale is? Employees are wielding executive power all over the place, and yet we've had civil service laws that give them substantial protection from removal for over a century. How about those?
Well, we do not challenge.
I know what you don't challenge. You're missing the point.
Well, then let me point the court to, if I could, to 7511B, of the civil service laws, the CSRA that we cite in our brief. That is a series of exceptions in it that provides no judicial relief at all to classes of employees, they're called. Now, some of those employees are clearly officers.
I haven't heard from Barrett or
for example,
Ketanji Brown Jackson yet.
Officers, Senate confirmed officials.
I want to see what Barrett does.
Substantial policy making or have confidential responsibilities, and members of the CIA, for employees of the CIA and the Foreign Service. So there's already been the political branches have in many ways already addressed issues with employees. Now, this court obviously dealt with.
We're already 20 minutes in, and this questioning isn't even close to over.
Proposed lines between employee and inferior officer.
Well, can I ask you
the court didn't decide those.
Can I ask you the same question, or maybe just a very similar question?
Thomas asked the first question. He's usually good about that.
You've been asked about a number of different agencies. A few of them are likely to come before us in the near future because of actions.
I think this is Alito. A little bit of that.
As you point out, have not been featured in litigation.
Northeast
of which
accent
I'm aware
muddled
up to
in.
this point. So suppose we were to decide this case in your favor without reaching some of the agencies that have been mentioned, like the tax court and the claims court.
If you're wondering what the case is about, I have a short video. It's other than my pinned, it's the first video in there. Go take a look at it real quick. It'll take me too long to get through it. I'm sorry.
To address those other agencies on what ground, one way or the other, to express a view that would affect those agencies either, as I said, one way or the other. On what would you propose that we say so as to reserve decision on those agencies that may not come before us in the near future or perhaps at any time in the future?
I would, I think, use the language that the court used in Free Enterprise Fund when it said we do not decide the status of lesser functionaries. It pointed out that the dissent in that case had itself pointed out that the federal bureaucracy is vast, and it said we don't want to decide, given the size and variety of the federal government, that discourages general pronouncements on matters that are not briefed and argued. Now, as to, for example, non-Article 3 courts, I'm not even aware of litigation about those removal restrictions for any of those.
But you're not using that sour logic has consequences. Once you use a particular kind of argument to justify one thing, you can't turn your back on that kind of argument if it also justifies another thing in the exact same way. And so, putting a footnote in an opinion saying we don't decide X, Y, and Z because it's not before us doesn't do much good if the entire logic of the opinion drives you there.
And quite a few justices are trying to get in.
Article 3 courts, because there the question would be, what are they doing? Is it judicial power or executive power? That's a totally different set of questions.
But I think Justice Kagan's point is that you're asking us to ask
that
question. And so we have to understand, you're asking us to ask the question with respect to each agency, what are they doing? That's the necessary result of the argument that you're making in this case. And I guess my point is one way to avoid these difficult line drawing problems would be to let Congress decide. I mean, I sort of thought that we have Article 1, which I think you agree gives Congress some authority to set up these agencies, to determine their structure, to create the offices that we're talking about. So it seems to me that greater power, we should at least think about whether it should include the power to determine the term of office, the extent to which people can be removed.
He's trying to overreach executive power.
Article 2 has some language in it that you're pointing to. But as Justice Sotomayor pointed out, the Constitution does not speak specifically to removal. You're asking us to infer this based on the Constitution's structure. And I don't know why we'd make that inference when the power to create agencies and set everything up lies with Congress.
That's accurate.
I agree with very much of
and
what
again,
you said, and so did James
the
Madison.
FTC Act of
1914
has specific reasons that you can terminate FTC commissioners.
But once Congress has done that, its power there stops.
Is that because of your democratic accountability? I'm trying to understand why you think that Congress is somehow less democratically accountable for the way in which it constructs these agencies and determines the term of office of the officers. You seem to think that there's something about the president that requires him to control everything as a matter of democratic accountability, when on the other side we have Congress saying we'd like these particular agencies and officers to be independent of presidential control for the good of the people.
Holy shit.
We're exercising our Article 1 authority to protect the people by creating this independent structure. And I don't understand why it is that the thought that the president gets to control everything can outweigh Congress's clear authority and duty to protect the people in this way.
So good.
Congress has a broad authority in structuring the federal government, but what it lacks authority to do is
if you're in here, if you can just tap a little bit, like fill up a bar, it would help so much. It helps the live. I appreciate all of you. Thank you for hanging.
The Constitution does not say that Congress cannot create an independent agency. So what is it about your argument that requires us to reach that result?
We disagree with that. We think the text of the Constitution confers the executive power, all of it, on the president. As Madison argued compellingly in the decision of 1789, the power to remove is an aspect of the executive power. Further, the text of the Constitution includes the take care clause. The take care clause, as the court has said virtually every time it's discussed this,
the text of the Constitution includes the necessary and proper clause, which gives Congress the authority to determine, set up, etc., these agencies to protect the interests of the people.
He's really doing
so
Madison for real,
I guess, and I'm just wondering why the president's interests in the way that you described them win.
Oh my God, she is not putting up with this shit today. She's like, bitch.
Congress to peel away executive power from the president and give it to someone who's not answerable to the voters.
Justice Thomas? Justice Alito?
Let me follow up on two things that have come up thus far. It certainly is an interesting argument. It's an interesting constitutional argument. It's an interesting political science argument.
Hold on. Listen to that language. Him saying this is interesting.
Allowing Congress to impose removal restrictions on the executive branch officers. When would you say the court crossed that bridge? And what have we said about that bridge in recent decisions?
Recently, the court, and in many decisions, the court has pointed out that the framers of the Constitution were not trying to prioritize efficiency or convenience. They were deliberately creating a separation of powers where the branches would check each other, and that's why the court should have sharpened rather than blunted review of encroachments by Congress that involve peeling away executive
Well, I mean,
power.
there's an argument that the Constitution doesn't say anything about the president's removal authority, and therefore Congress should have free reign in that era, on that question. When did the court cross that bridge?
I think the court, if you're saying cross that bridge, I mean, when did the court adopt that view?
When did the court say that, no, Congress doesn't have plenary power to impose removal restrictions on executive branch officers?
No later than Ex parte Hennon in 1839, when the court said that, referring to the decision of 1789, that this is the settled and well understood construction of the Constitution, that the president alone has the removal power.
How about Myers?
Myers was also very clear on that in 1926. And in fact, Humphrey's executor itself paid lip service to it, even though its heart was far from it.
It's been suggested that if we were to rule in your favor about the Federal Trade Commission, put aside these other agencies, just about the Federal Trade Commission, which is the issue that's before us, the entire structure of the government would fall. You want to take a minute to address that?
The court in, I think, Free Enterprise Fund or Seal Law talked about these kind of predictions of doom, and the sky
This
did
is an
not
interesting
fall
line of questioning for Alito.
The CPSC and the PCAOB. So also if the FTC, the MSPB, the NLRB are made subject to
I mean, he'll give lip
process,
service
the
to Trump's
discipline of being
ass, but
accountable to
this
the
is
president, the sky will not
interesting
fall.
for
In
him. This
fact,
is
our
not a
entire
normal.
government will move towards accountability to the people.
Thank you.
Justice Sotomayor?
Counsel Myers, which you rely on, was signed by a number of judges. One of them was Justice Sutherland, and he was the author of Humphrey's executive.
Yes, he was.
So
He wrote the
4
opinion
out
of the court.
9 justices who signed on to Myers
They
signed
found
on to
it
Humphreys.
distinctly different.
So you're thinking, or you're arguing, that the reasoning of the more current justices on this court have more purchase than the views of renowned jurists like Holmes and Brandeis, who dissented in Myers, of people like Justice Story, who disagreed with this proposition. You're suggesting that we have a better view than either Congress or all of those previous justices.
Because Congress
About
doesn't
what?
legislate.
Absolutely.
Or, I'm sorry, the
Executive
justices
power
don't legislate.
means.
I
That's
apologize.
basically your argument. All those justices in the past have been wrong. And the current ones are right. Or at least the current ones of the Shigella law majority.
I'd say 2 things in response to that. I think the court was correct in the following decisions: Ex parte Hennon, Parsons, Shurtleff, Myers.
Those all
Seal Law.
involve different and distinguishable situations.
Thank you.
Now, with respect to the one component of government that you're not speaking about, when the FTC was created, as has been the case with most of these independent agencies like the Federal Reserve.
I know where she's going with this.
Particularly there, but not that much lesser with the FTC. Congress emphasized the importance of independency and the prestige that independence would give to the decisions of agencies.
This is a pinnacle point in that original Humphreys executor decision.
Of which there might be burdens. And that independence is being taken out or undercut completely. Why are you so sure that Congress would have preferred to have the independence narrowed
In fact,
not
in
to have the
Humphrey's
agency at
executor,
all.
they
Some of
pulled
my colleagues have
the
suggested
original meaning and the
in prior
transcripts from
cases
Congress and
that
reviewed it.
we shouldn't be engaged in the severability.
Because the FTC
Actions
Act
at
of
all.
1914 isn't that
But
old.
here you are arguing that, no, we should be doing that. Why? Are you going to be consistent?
The prestige, I would say two things.
Oh,
in response
she
to that.
said
The prestige of independency is
It
not
can
a
be
constitutional value.
consistent.
The constitutional value is the separation of powers and the vesting of all the executive power in the presidents. That is the
According to the
constitutional
laws that Congress makes. And that's the point Justice Jackson was emphasizing.
Yeah.
What you're saying is the president can do more than what the law permits.
Yep. That's exactly the argument they're making.
I think I would repeat what
That
I
the
said
president
before. There's a
gets to
strong
sort
line
of
precedent recognizing
deviate
that the text
from
and
the
structure of
actual law on the
Constitution
books.
confer on the president the exclusive and illimitable power to remove executive officers, and as a result of that, Humphrey should be overruled.
Justice Kagan?
General, would you agree with me, and I hope you will agree with me, because this seems to be the one thing on which everybody can agree, that if there's one thing we
This
know
is
about the
Kagan?
founders, it's that they wanted powers separated. They wanted the executive, the legislative, the judicial. They didn't want them all in one place. They
want
wanted
them to
separated
check
across the
each
government,
other.
across the different branches. Easy enough
Checks
to
and
agree
balances.
with, right?
I agree with an important caveat that the court said in the
Oh.
law that the one, sort of exception to all this division was the presidency itself, where the framers consciously adopted a unified and energetic executive.
Oh,
That's not a caveat.
so they're arguing for the unitary executive.
Or
That's
codicil.
actually, that's like the not X to my X. Because what I was saying was, and maybe you knew where this was going, so you had to have this caveat, which is really a fundamental contradiction. But the idea is that the president was supposed to do the executing. But he wasn't supposed to do the legislating, and he wasn't supposed to do the judging. And here's like my next proposition, which I think you have to agree with, because we just look around the government and it's obviously true. Some people think it's a real distortion from what the founders thought, but these, what you think of as executive branch agencies, including independent agencies, right? They do a lot of legislating, and they do a lot of judging. And you listed it a bunch of times. You said, this is obviously executive power. Why is it obviously executive power? Because they're doing a lot of rulemaking.
That attorney is
and they're
John
doing a lot
Sauer,
of
and yes, he does
adjudications
sound like
leading
RFK.
to enforcement. And those are, although we've said that this is executive power in some sense, but they're legislative functions. That's what rulemaking is. They're adjudicative functions. And isn't it problematic, given what we know about the founders' vision, that what this is going to amount to at the end of the day
Oh, she's making a
is putting
play
not
to
only all executive power
originalism.
in the president, but an incredible amount of legislative / rulemaking power and judging in the president's hands?
I disagree. I got off I started disagreeing very early in that question, and I think I can pinpoint it this way.
Oh, God, just pinpoint it.
The mere fact this court held, I think every justice agreed in FCC against Arlington. It's been reassorted. It was the vision of Morrison. It was recognized in Morrison.
I will stop the live and I will address this once. If you don't like that I'm speaking during this, go watch it on your own. You can go to the SCOTUS website and do it yourself.
Way. Here's been the bargain over the last century, and I think it has been a bargain. Congress has given these agencies a lot of work to do that is not traditionally executive work, that is more along the lines of make rules when we issue broad delegations and do lots of adjudications that set the rules for industries and entire bodies of governance, right? And they've given all of that power to these agencies, largely with it in mind that the agencies are not under the control of a single person, of the president.
Exactly.
But that indeed Congress has a great deal of influence over them
Kagan
too.
is fucking slaying.
And if you take away away a half of this bargain, you end up with just massive, uncontrolled, unchecked power in the hands of the president. And it's really hard to affect both sides of this bargain because it's already been done. So the result of what
she said you already did it
is that the president is going to have massive, unchecked, uncontrolled power, not only to do traditional execution, but to make law through legislative and adjudicative frameworks.
Loper-Bright actually took away executive regulatory authority.
The way you framed it there, I think, makes the separation of powers problems in the alternative view here even worse. Because you have just described these rulemakings and adjudications as really judging and legislating. If they really were that, which this court has unanimously said they must not be, they cannot be. But if they were that, then Congress is not just affecting the executive, it's creating junior varsity legislatures, which would be unconstitutional under Justice Scalia's dissent in Mistretta. It's peeling away adjudicative authority, the judicial power from Article 3 courts.
I understand that as a formal argument, and obviously formal arguments play a significant role in this area, but they shouldn't blind us to the real world realities of what our decisions do. And the real world reality of this
is a dissent.
Is
it was
that
a Scalia
when you put
dissent.
all of these agencies under complete presidential control, given what Congress has already done and will not be able to take back with respect to the powers that have been delegated to the agencies, what you are left with is a president that maybe, your first sentence to me, this is the kind of president you want, but a president with control over everything, including over much of the lawmaking that happens in this country.
You have control over the executive branch, which he must and does have under our Constitution. And again, if that's really legislating, then there's a separate constitutional problem that the legislative power has also been taken away from Congress. Now, this court has not.
It's actually a good rebuttal on his side to Kagan. I'll give him that.
Including Steele Law, the court has correctly recognized.
I don't like John Sauer's voice. I don't like his arguments, but I can recognize a good argument.
Executive power. That is fundamental to our separation of powers, which is the bastion of individual liberty in our constitutional structure.
Thank you, General.
Justice Gorsuch?
General, let me suggest to you that perhaps Congress has delegated some legislative power to these agencies. Let's just hypothesize that. And let's hypothesize, too, that this court has taken a hands-off approach to that problem through something called the intelligible principle doctrine, which has grown increasingly toothless with time. Is the answer, perhaps, to reinvigorate the intelligible principle doctrine and recognize that Congress cannot delegate its legislative authority? Is the water warm, General?
Sorry, what was the last? I couldn't hear the last bit.
Is the water warm?
Is the water warm? Suffice to say, let me say one thing in response to that.
See his follow-up.
It is much easier to cure. Obviously, members of this court have debated the scope of the non-delegation doctrine. The challenge of finding the right standard there is something we've discussed in the past.
FTC commissioners have term limits per Congress, 7 years.
Power is right there in the statute. It's easy to remedy by excising the removal restriction.
There are a lot of wolves around here, General. That one thing our framers knew is that every political actor seeks to enhance its own power. We all know that to be true from our own experiences. And this court, as part of this bargain, has allowed these agencies to exercise both executive and legislative. Justice Sutherland, whose name hasn't been invoked around here in quite a while, his language about quasi-legislative and quasi-judicial and quasi-this powers. And this court has allowed that for a very long time. But if we're not going to allow it any longer, I take the point that this has allowed a bargain where a lot of legislative power has moved into these agencies. But if they're now going to be controlled by the president, it seems to me all the more imperative to do something about it.
I agree with that, and I can't address all the wolves.
Gorsuch is gone then.
Wolf, when it comes to constitutional structure, is Fenris, the most dangerous wolf
Let's watch
in the history
Barrett's
of
questions.
And let me ask you about the judicial power. To the extent we're worried about the tax court,
the
court of claims, maybe despite what people think, maybe some of them might be. I don't know.
Police.
They're Article 3 courts, and the removal restrictions are impermissible. Thoughts?
There definitely could be arguments on that. I'm not taking a position on the validity or non-validity of any of those, which are not presented here. But
I could be wrong, but I'm
the
sensing
magistrate
that.
judges and the bankruptcy
We'll
courts.
See. I have to hear the other part of the argument.
Adjuncts to Article 3 courts, and an argument might be made of that nature. There are line drawing problems there. We haven't addressed them here. I don't have the federal government's concerted answer to that, but certainly those line drawing problems.
Kavanaugh gave me less.
Whether what is going on is judicial power.
Roberts is always hard to sense. But I want to watch Barrett.
Private rights is different.
I want to watch Barrett. I want to watch Kavanaugh. I want to watch Roberts. I may have called Gorsuch wrong.
Those line drawing problems.
Justice Kavanaugh?
Response to Justice Sotomayor's question, you have Taft and Scalia, right? It's not too shabby.
I think those are outstanding jurists, and with respect to Justice Scalia in particular, one of the greatest jurists in the history of the court.
I thought your two exceptions that you've had a lot of questions about, but I thought the two exceptions, the categories were one, the Federal Reserve, based on history and tradition and function, and the other were the non-Article 3 courts, which starts in Marbury. Marbury itself discusses this. Taft discusses Marbury at length in Myers on this exact point of non-Article 3 courts being different. Taft leaves that open, right, in Myers.
Yeah, this is Kavanaugh.
And so for Court of Federal Claims, Tax Court, the D.C. local courts, you mentioned this at page 23 of your brief, it would seem to me that Marbury itself says that is a line that distinguishes the non-Article 3 courts from the position that you're taking here. I know you may not agree with that, but is that a principled, sensible line we could draw?
Certainly it is something that the court could look at. I don't want to take a position on them. To be clear, I am not taking a position on whether that line is valid, but certainly there are arguments that could be made and debated in an appropriate case about where those lines should be drawn.
Yes, this is live right now.
And you do, I think, correctly reference both Myers and Marbury itself as teeing up some of those issues.
There's been debate about Marbury.
Was that about
DC or was that about judicial office? But I read it to be some of both, so for what that's worth. Why did no president challenge this structure from 1935 to 2025?
That's
We've had
a
lot
good
of presidents
question.
Who had very strong views of Article 2. Yet for
Kavanaugh's
90
dropping
years,
a banger.
Stood not directly challenged. Why do you think that is?
It'd be speculative to answer that. I mean, one reason might be that presidents are fairly comfortable with taking away tough political decisions. So as the court has said in multiple cases, I believe one president cannot bind the hands of his successors. And the president, there's a kind of responsibility that goes with the authority here. The president sometimes may have a political incentive to allow tough decisions to be outsourced, so to speak, to agencies that he doesn't have direct control over. However, our constitutional structure dictates that the president cannot do so. He cannot bind the hands of his successors, or the encroached upon branch cannot consent to the encroachment, and therefore disrupt our constitutional structure.
One thing you've said, but I want to make it crystal clear, that overruling or narrowing Humphrey's executor would not threaten the existence of these agencies, but only would alter how the heads of those agencies can be removed, correct?
Correct. They'd be politically accountable to the president.
They'll be back in a year arguing
these kinds of broader
exactly what he just postulated. Should they give him this?
The way we've done it is to sever the removal restriction, not to destroy the agency, correct?
That's exactly right.
On stare decisis, you used the word dangerous, I think, in your opening about the independent agencies. One of the things we consider are not only how wrong it was and reliance interests, but the real world impacts. And I think,
Davo, can you watch for like 2 seconds? I just got to run in and get something to
when talking about independent agencies, if I heard that correctly.
And maybe to return to the exchange I had with Justice Kagan, the real world consequences here are human beings exercising enormous governmental authority with a great deal of control over individuals and business, small and large businesses and so forth, who ultimately do not answer to the president. That's a power vacuum. The president is answerable to the voters. They have no boss. And regardless of what happens, when there's a power vacuum, somebody's going to come into that power vacuum. So is it Congress that many commentators have noted actually exercise substantial control over these independent agencies through budgetary functions and through oversight functions? Is it industries engaging in industry capture of the agencies? The point is that power vacuum should not exist in our constitutional structure because, as Madison said, there's a line of accountability, a chain of dependence that runs from the officers to the president, and he's answerable to the community, which is the voters, every 4 years.
I want to return to what Justice Kagan and Justice Gorsuch were
There's
talking
three
about with you
specific
in terms of the bargain.
Removals, malfeasance, neglect of duty, or inefficiency.
Independent agencies
Trump didn't know.
raise enormous constitutional and real-world problems for individual
I'll beat you up,
liberties. You
Davo.
just mentioned, I've obviously said that many times in prior opinions. I thought one aspect of that we've taken great steps
Thank you so
to
much for your
correct
likes and
has
follows.
been the
You are
major
all
questions
amazing.
doctrine over the last several years to rein in what Justice Kagan was talking about, these broad delegations, to make sure that we are not just being casual about assuming that Congress has delegated major questions of political or economic significance to independent agencies or to any agencies for that matter. You want to speak to the major questions doctrine and how that fits into your answer?
Suffice to say that the major questions doctrine is not a substitute for the president's removal power. It may have done some work in backstopping the fact that we do have these independent agencies without a political discipline, but the president's removal power is what is dictated by the Constitution, that the president must have the power to control, and that these agencies, the one who has the power to remove
threading the needle,
is the person that they have to fear.
But I don't think he's firmly this
Sorry
or
to
firmly
prolong
that.
this, but on your second question
I want to
presented,
watch
on the
his
second
questions
question
later.
presented, I just want to touch on that quickly. This is about the reinstatement argument that you make. I have some real doubts about that argument. We don't need to reach it, of course, if we agree with you on the first question. I have some doubts about that because that really would be an end run around the exceptions you had identified earlier for the Federal Reserve or for the non-Article 3 courts. In other words, you could just remove those people, and so long as you continue to pay their salary, you wouldn't have to reinstatement. That strikes me as really destroying the categories that you had identified as potential exceptions. So I'm concerned about your reinstatement argument on question 2, and just want to give you a chance to address that.
Maybe I could just say two things. I think that this court in its Wilcox-Harris stay opinion said something very telling. It's not binding on this issue, but it's very persuasive when it talks about how when it comes to the balancing of harms, the injury to the government from being forced to take back into the fold an executive officer that the president's
Sorry, I need a break from that voice for a second. He's going to rehash the same shit for another 5 minutes. So I want to be clear. The attorney arguing for Rebecca Slaughter, this is their first time in front of the Supreme Court, but they did clerk for Alito and one of the other justices. I can't remember who it is right now. However, I'm concerned this is not a time where you want it to be your first time. You don't want to be popping your cherry on this case. I said what I said. We'll see how it goes, but oh my God, no.
The separation of powers, right? Because
I can hate John Sauer, but he's a good attorney. He knows his shit.
Officer, it just doesn't raise all these issues, and that's why the answer to that concern when it comes to Article 3 courts is not, oh, the president doesn't have removal power. It's that are these Article 1 or are these Article 3? If they're in Article 2. If they're in Article 2, the president has control. If they're in Article 1, then it may look very different.
Thank you.
Justice Barrett?
So, General Sauer, you argue that the removal power comes from the vesting clause. And I understand why you make that argument, because that would be the broadest authority, because it would give, that would be the full unitary
It would be like
theory.
sweeping.
But there are other theories of where the power could be located. For example, if it was part of the take care clause, then it might be more limited, because it might apply only or give removal authority only over those officers who exercise significant discretion, or it might be an adjunct to the power of appointment. which would mean that inferior officers didn't come within it. And I don't read our cases to this point to really be very specific. They mention all three, and they could be mutually reinforcing. Is there any reason for us to be specific about it in this case?
I think the court ought to adopt, as I read the cases, virtually every time the court has decided this, certainly in Seal of Law and Free Enterprise Fund, but also going back to the 19th century cases, the court looks to both the vesting clause and the take care clause. And then in other cases, it also refers to the appointments clause and how the power to remove also flows with the power to appoint. So you have three kind of mutually reinforcing textual bases to place what, again, the court's decisions from ex parte Hennon through Humphrey's executor decided as a settled beyond doubt, exclusive and illimitable power of removal. So I think the text of the Constitution supports what you've referred to as the strong theory, and that's, I think, repeated again and again in this court's decisions, where it started with the vesting clause. And of course, it's the logic of Madison's statements on the floor of Congress.
Oh my God.
Well, let's see, I know that obviously, I understand that's your first line position, and I do think that you could go back through the cases and find that, and I agree with you that we mentioned the vesting clause. I agree with you, it comes up in the decision of 1789, et cetera. But what I'm asking is there any reason that we have to? Because it seems to me that they're very hard questions. Justice Kagan in particular was pushing you on them about what the limits of your logic would be. And it seems to me that, and there's some dispute among this in the amicus briefs and the scholarship about which portion of Article 2, or if it's in the appointments clause, would be the source of this authority. And is there any reason we have to decide that here, given that it might be relevant to some of the harder questions about limiting principles?
I don't dispute that there might be narrower grounds on which the court could rule, but we'd encourage the court to adhere to the logic of all those decisions. Again, I've
let me tell you the problem the executive or the justices are running into right now.
Exclusive and illimitable, conclusive and preclusive.
They don't want to give you unlimited power, and they know how this is going to play out.
Successfully advocated.
I can tell by the questions they've asked.
So we have to do vesting clause.
We think the vesting clause provides at least the clearest textual basis for it. I mean, when Madison said, for example, the power of overseeing, controlling those who execute the laws is the quintessential executive power, that's the logic of it. Could the court,
to be clear, this conclusive and preclusive, Barrett wrote the immunity ruling.
Devising that holding, I was just proposing not being very specific about it.
Oh wait, no, she didn't write the immunity ruling. I'm sorry, she wrote another one.
But let me move on. And actually, this is a
question
she
dissented in the immunity ruling.
I truly don't know the answer to, and I just thought of it during the argument as we were talking about bargains. So both Justice Gorsuch and Justice Kagan were asking you about the bargain that Congress has made in creating these independent agencies.
Well, then go and start your
And
own
I was struck by, I remember Justice
is.
Gorsuch brought up in the tariffs argument the fact that that tariff statute had a legislative veto originally. I don't know whether the original 1935 FTC Act from Humphreys did or did not. But I guess the question that I have is that part of the bargain, because legislative vetoes were pretty ubiquitous throughout the 20th century, and of course we held them unconstitutional in Chadha. And if you had a legislative veto, even if Congress wasn't exerting itself the authority to fire the head of a multi-member board, it could override decisions that the agency made. But I think I gather your point, part of your response to Justice Jackson about why these agencies are different is it's not like they're answering to Congress either. Congress creates them and it might put the removal restriction on them, and that might limit the president's authority, but they're not answering to either the president or to Congress. But when the legislative veto was in place, there was some measure of congressional control that is perhaps more significant than budgetary restrictions. I just wondered if you could speak to that.
Two things. INS against Chadha correctly recognized that there was legislative
I wasn't questioning Chadha.
And Chadha,
we're about 55 minutes into the argument.
That's terrible. That is a huge separation
They're
of
normally
powers
limited
problem.
to 40.
Congress is attached a string to its delegation to control what executive officers are doing. And then the historical point that in Chadha, by the time of Chadha, that had been in place, legislative vetoes had been in place since 1932, over 50 years. There were 196 statutes with 295 legislative vetoes, and this court said they're unconstitutional. And the fact that Congress likes this encroachment power so much sharpens rather than blunts the court's review.
But that's not quite the question that I had. I guess what I was wondering is, do you think it's part of the reason Congress was willing to infuse agencies with a lot of the broad powers, Justice Kagan was pointing out, they now exercise a lot of rulemaking power. There's a lot of adjudicatory power. And I'm not questioning Chadha. I think Chadha, rightly, as you said, made the separation of powers point that Congress can't retain this power for itself. But I guess what I'm saying is, having lost that check, maybe these independent agencies have become something that Congress didn't intend or anticipate even at the point that it set it up, which is the point that Justice Gorsuch made in the tariff argument with respect to IEPA.
She's setting it up for the premise that the Trump team delivered, which was that, well, they've assumed too much authority.
It started coming in vogue in 1932, and the FTC Act goes back to
Disappointed,
1913.
Barrett.
So I'm not sure if that's part of the dynamic.
Let me ask you a question about stare decisis. How should we think about reliance interests when it comes to reliance interests in government structure? You know, Justice Sotomayor was pushing you about, had we ever overruled a case that was this old? And you gave lots of examples, and frankly, examples that Erie kind of came out of nowhere in overruling Swift, right? And here I would say there's been an eroding of Humphrey's executor over the years. But I think what Justice Sotomayor was really trying to get is not at, was there as an age gap, but this kind of decision. And I'm not asking you whether there's been another analogous decision, but I think when we think about stare decisis interests, this kind of structural interest, which is really the interest that's been identified on the reliance side. Can you think of a case that talks about how the reliance factor of stare decisis plays in here?
I think Justice Gorsuch's opinion for the plurality in Ramos addresses this when he talks about how you're weighing. Here you're weighing an injury to the constitutional
I'll be live
structure.
for birthright citizenship, barring anything happening.
The reliance of the American people in separation of powers and defending our liberties. If
I'm
you look
live
at
all the
like
time
human
for
reliance
Supreme
interests,
Court
like,
cases.
Entering in a marriage, starting a small business, and so forth, you don't see a lot of people making, decisions in reliance on the fact that there are, multi-member agency commissions have removal restrictions. The only actor here who's arguably relying is Congress, and Congress.
They haven't put it on the docket yet, as far as I know, but I'll double check today.
And where that's the case, the
Thank
supposed
you
congressional
for the likes
reliance
and the
interest should
follows.
be given
Y'all are
no
amazing.
weight in our view. And then, I think I'll say that.
Justice Jackson?
So I guess I really don't understand why the agencies aren't answering to Congress. Congress established them and can eliminate them. Congress funds them and can stop. So to the extent that we're concerned that there's some sort of entity that is out of control and has no control, I guess I don't understand that argument.
We would say the constitutional actor on the hypothetical who is
I
controlling
have everything up through the January docket, unless they tack it on.
Well, I understand. I'm just talking about as a practical matter.
But
Part of
they
their
haven't
argument
set it to the
seemed
docket yet,
revolve
probably
around this
February.
notion that there's some kind of thing happening with the independent agency.
But it may be
that
expedited,
the reason why
so
the
we'll
president
see.
needs to control it is because they don't answer to anybody. And what I guess I don't understand is why they don't answer to Congress, which establishes the law that they are bound to follow and determines whether these agencies exist, funds these agencies, all of those things, it would seem to me, would be methods or mechanisms of control.
The Constitution requires clear lines of political accountability. So if Congress is sort of informally actually controlling these agencies through like oversight.
Not informally, we have a statute, but let me ask you another question.
She said no, we already got that written down.
I have a very different view of the dangers and real world consequences of your position than what you explored with Justice Kavanaugh. My understanding was that independent agencies exist because Congress has decided that some issues, some matters, some areas should be handled in this way by nonpartisan experts.
Yes.
That Congress is saying that expertise
so
matters with respect to aspects of the economy and transportation and the various independent agencies that we have. So having a president come in,
presidents directly
and fire
appoint a transportation
all the scientists
secretary
and the doctors and the economists and the PhDs and replacing them with loyalists and people who don't know anything is actually not in the best interest of the citizens of the United States. This is what I think Congress's policy decision is when it says that these certain agencies we're not going to make directly accountable to the president. So I think there's a pretty significant danger that Congress has actually identified and cares about when it determines that these issues should not be in presidential control. So can you speak to me about the danger of allowing in these various areas the president to actually control the Transportation Board and potentially the Federal Reserve and all these other independent agencies?
I think the court said it well in Free Enterprise Fund when it said that we can have a government that functions without rule by functionaries. We can have a government that benefits from expertise without being ruled by experts.
No, we can have, but I'm asking you about Congress's choice, Congress's decision that
she said, bitch,
in these
answer my
particular areas,
question.
we would like to have independence. We don't want the president controlling. I guess what I don't understand from your overarching argument is why that determination of Congress, which makes perfect sense given its duty to protect the people of the United States, why that is subjugated to a concern about the president not being able to control everything. I mean, I appreciate there's a conflict between the two, but one would think under our constitutional
they're doing
design,
a good job
given
of
the
keeping
history
him
of the
on
monarchy
point.
and the concerns that the
to go
framers
off
had
on
about
weird
a
shit
president controlling
sometimes.
everything, that in the clash between those two, Congress's view that we should be able to have independence with respect to certain issues should take precedence.
The constitutional design sets up 3 branches of government. It forbids Congress from controlling what the executive branch does, and it also forbids Congress from shaving away the president's control.
And what I'm positing is that Congress's decision here is not shaving away the president's control. You cast it as that, and I appreciate that, but instead, what Congress is doing is saying we'd like to have independence, nonpartisan experts working on certain issues for the good of the American people. And I understand that the president would rather control them, but it's not really his decision in the overall scheme of things, I say. Why am I wrong about that?
Under the constitutional design,
it is the president's decision as to how the government is structured and who should
It feels
be doing
like
what.
a lot of this argument is really falling back to
Congress cannot violate the
is the
separation of powers and
FTC
threaten all of our liberties in
exclusively
the
an
way that it
executive
structures the
branch?
government, and it has done so here.
One last question. I appreciate the effort to try to make this not seem as big a deal as it might be by focusing only on the FTC and saying this is really just about what happens and we'll cross the bridge of the other agencies when we get to it. But can you just
She said,
give us a sense, 'cause
you're
I'm
just
sure
trying
you
to
must
make
know
it not a
this,
big
of
deal, but it is.
what other agencies there are that have the kind of removal protections that are at issue here? There's some.
Yes, a lot of
2
the-
dozen?
That's what Seal Law said. That's probably a good accounting. And obviously, we have challenged 4 of them in this court, and we're challenging a handful of others.
But you could challenge the National Labor Relations Board, the Nuclear Regulatory Commission,
Yes.
the Commission on Civil Rights, potentially the Sentencing Commission, the Occupational Safety and Health Review Commission, the Consumer Product Safety Commission. All of these have that kind of structure.
I don't know if all of those are on the list. Certainly some of them are. And some of them, in many of these agencies, we are.
She's saying there's going to be
including in this
fallout from
Thank you.
this because if we decide you can do this now, you can do it to anybody.
Mr. Agarwal?
Agarwal, this is
Mr.
for
Chief
Rebecca
Justice, and may it
Slaughter.
please the court. The president's constitutional duty to execute the law does not give him the power to violate that law with impunity. But petitioners claim that the president was free to fire Commissioner Slaughter without cause in violation of the FTC Act as authoritatively construed by this court. And they urge, even if that firing was illegal, there is nothing that any court anywhere at any time could do to remedy
That's
that
the
violation.
problem.
The district court correctly rejected both arguments, and its judgment should be affirmed. On the merits, multi-member commissions with members enjoying some kind of removal protection have been
He's
part
going
of
to
our
make
story
too many
since
concessions. I'm
1790.
calling it now.
So if petitioners are right, all 3 branches of government have been wrong from the start. Congress and prior presidents have been wrong to jointly create early founding era commissions and more than 24 traditional independent agencies since 1887. And this court was wrong.
It's not how
to
the
repeatedly
government
bless
works,
those
Mortgage
laws
Pro.
And to unanimously uphold the exact same removal provision.
Yeah, this
at
is
issue
Cherry
here
Pop
in
Lawyer.
Humphrey's Executor almost a century
This is
ago.
not the case
Reasonable
for
people
this.
can and do disagree about first principles, but any abstract
They're literally
theory
handing
that
Sauer
would
a
wipe away
win,
so
and I
much
fucking hate
history
it.
and precedent should be a non-starter. At a minimum, petitioners would need an airtight theory to justify the radical change that they now seek, and they don't have one. No tool of interpretation clearly supports the president's assertion of an unrestricted and indefeasible authority to fire the heads of traditional independent agencies like the Federal Elections Commission and the Nuclear Regulatory Commission. Plus, petitioners' theory cannot be reconciled with their own apparent position on the Federal Reserve and Article I courts. Finally, stare decisis militates against overruling a century of precedent
but I'm
at this
calling
late
it.
date.
He's going to waver, he's going to get scared, and he's going to make too many concessions. We'll
finding
see.
Reasonable legislative solutions
We'll see where we get.
that strike an appropriate balance. That kind of legislative solution is far preferable than abandoning a foundational precedent on which so much of modern governance is based. I welcome the court's questions.
Was Humphrey's an executive branch case?
It was an executive branch case, Justice Thomas, insofar as the FTC is an entity that is not operating under the auspices of Articles 1 and 3, but it is also a case in which Congress and the President coming together have determined that it's not part of a traditional executive department. And
did the court in Humphrey's executor distinguish it from Swift?
Yeah, Mortgage, that's the whole problem, is that he fired somebody that had specific removal protections. They could only be removed for inefficiency, neglect of duty, and malfeasance, and he didn't remove them for any of those reasons. Go watch my video and come back when you're a little bit smarter.
It was based in part on functions, Justice Thomas, but it was also based on the placement of the agency and the considered determination of Congress and the President together that this was the kind of agency that should be insulated from presidential at-will removal.
Now, you rely on the reliance into interests.
On the fucking text. They're relying on the fucking text.
The reliance interests of Congress and reliance interests, I guess, of others of the agency heads on the structure of this agency.
Thank you all. I had
two
people help me with it, and it turned out really good.
The FTC is 111 years old.
But from Humphrey's executor?
90 years.
And how would you have applied that in the overruling of Swift v. Tyson, your reliance interests?
Yeah, so Swift v. Tyson deals with a completely different kind of situation with respect to the Erie Doctrine.
So there was no reliance interest?
So reliance interest with respect to choice of law.
Oh, I didn't make the connection. I'm sorry.
I haven't thought through that systematically, Justice Thomas, to tell you the truth. I do think that there is a reliance interest here that is both immense and undeniable, and that is the fact that Congress and the President have determined that there are certain statutory authorities, not constitutional authorities, that statutory authorities that the executive branch would never have in the absence of congressional legislation.
You're welcome. If you're not aware of the background of the case, I do have a video in my profile.
Of just one person. And that reliance interest would be completely destroyed by retroactively destroying the independence of traditional agencies.
So this is, I don't know what a traditional executive administrative agency is, but could Congress limit the removal authority of the president in a newly created executive branch agency? Let's say, for example, a few years ago, EPA became an executive branch agency. It was more
because Congress gave it to him, Tammy. That's the way it works.
Could it, in doing that, limit the removal authority of the president, of the head of the EPA, or Homeland Security?
I think it is within the realm of possibility, Justice Thomas, and I don't think that the court ex ante should adopt any kind of categorical rule precluding that.
No, I'm trying to, again, the SG was asked about the logic of his argument. What's the logic of yours? How far does it carry you? If this is an executive branch agency, and your distinction is this is a multi-member agency,
because it's a government agency, not a private business, Tammy. Go get your friend Mortgage Pro back. So
you're asking whether a single-headed agency could be converted into...
No, I haven't gotten there yet, but that would be the next step in order to make them removable.
Thanks, Dagny.
To make them the heads of the agency or the principals removable.
Mm-hmm. So there are constraints. One of the constraints
Law
is
may
that
come
the
in
creation
later,
of the
but he's
agency
got a
and
busy.
the insulation from
his
presidential
docket's busy this
control
morning.
cannot interfere with the president's conclusive and preclusive constitutional
But you
authorities.
still haven't told me, why can't tomorrow morning Congress decide that the Secretary of Congress should be removable and they should limit the president's authority to remove the Secretary of Commerce?
That would be squarely foreclosed by this court's decision in Seal of Law as we understand it. And that is to say, this court in Seal of Law held that there is a particular serious threat to individual liberty that is posed by single-headed
It's a
agencies
stupid question.
that
Go
wield
watch my video,
significant
Tammy,
executive
and then
power.
you can come
Congress,
back.
Convert all these departments into multi-member commissions, the Commerce, EPA, Department of Homeland Security, Department of State, convert them all into multi-member commissions and make them removable only for cause.
No, I think Justice Kavanaugh, we're looking at three buckets here.
That's an okay
in one
question.
bucket, including the Department of State, you would have
Not the fucking
departments
buckets.
that under no conceivable circumstance could practicably be converted to a multi-member commission because they are wielding so many of the president's conclusive and preclusive constitutional authorities. But that is a relatively small bucket. Let's say Department of State,
Justice and Defense.
Justice, Defense, Homeland Security, probably.
Are you saying, though, that they're limited by practical concerns or constitutional concerns?
Constitutional concerns, and then practical concerns will come up as well.
Well, let's put aside the practical concerns. I'd like to understand just the answer to Justice Kavanaugh, why tomorrow Congress couldn't
Maybe this may be Roberts.
transform every cabinet official into
Gorsuch,
a
Roberts, and
multi-member.
Alito sometimes run together for me,
What's
so
the
I apologize,
constitutional
guys.
problem with that, I think, is what my colleague was getting at.
Absolutely.
I
And
think
the
it may be
constitutional
Gorsuch, though. It
problem in
sounds
our
more
view is that Congress
definitive.
cannot limit the president's authority over officers who are wielding the president's conclusive and preclusive constitutional powers. And that is a line that goes all the way back to Marbury v. Madison. It's a through line through this court's jurisprudence,
Does it
including
include-
Justice Jackson's.
The FTC has the authority to enter foreign agreements, right?
Barrett.
How do you decide what's conclusive and preclusive?
It does not have the authority to enter into foreign agreements on its own, Justice Barrett. The statute expressly provides that the Secretary of State's approval is required before any kind of agreement is executed, and the Secretary of State, of course, is subject to the president's plenary removal power.
You talked about three, I'm sorry.
I just want to make sure I understand because it's fairly basic. I mean, are there some cabinet departments that you say Congress could just take over?
This is
Department of
Roberts.
Veterans Affairs, Department of Education. They think, well, experts can do a better job of it. And so we're going to say there is now an agency, the Agency for Education, and it will be run by, whether it's a multi-member group or not. We think it's important for Congress to have greater control over education. So we're creating this new agency, and its authorities will be everything that the current Department of Education has, except it will be run by a commission, and they can only be removed for cause. Is that all right?
Yeah, I think that it is probably within the realm of possibility for agencies. Yes, Chief Justice Roberts, and the constraint historically has been that these types of determinations have been made through a process of political accommodation between Congress and the president, and over the course of more than 200 years, we have not seen.
Well, I mean, I'm
Barrett,
sorry,
Roberts,
but sometimes that accommodation is greater than
Kavanaugh,
other
I
times.
think,
I mean, we
are
have
the
situations,
ones
let's
to
say,
watch.
where the Congress, both houses are controlled by one party, and the president is of the same party, and they may decide that the government would be structured better than by taking over these entities. And so which departments could Congress impose a multi-member commission instead of a secretary?
Yeah, so if you're asking about which ones could be converted today, I think it's probably a pretty small universe in terms of the numbers that could be wholesale transformed as they are currently constituted. Why? Because it appears that the vast majority of executive departments wield at least some powers that this court would deem to be conclusive and preclusive, including under the standard that this court enunciated.
I'm sorry, keep going.
including under the analysis that this court set out just last term in Trump v. United States, where at pages 620 to 621, the court explained that the president does have a conclusive and preclusive authority with respect to certain criminal investigations and prosecutions, and that informed the court's determination about whether the acting attorney general was subject to at-will presidential removal. It turns out that the vast majority of these executive departments do have some kind of criminal investigative authority, including armed law enforcement agents authorized to make arrests. Now, that's a significant bucket. You probably have
every agency in the government today has armed police officers, their own police force. Is that really the test of what's conclusive and preclusive?
So we're not saying...
It rhymes, but I don't know what it means.
Justice Gorsuch, I think you're making a good point insofar as you're saying there's insofar as Your Honor's point is that there's a lot of what these agencies do that would not be deemed conclusive and preclusive, and we absolutely acknowledge that. And
so the problem is that it falls under lots of buckets of authority, right? Like they have these powers, Congress granted them this. That's the entire issue, is that it's not solely executive. And maybe they're right to question, like, why would you create an agency like this? I think those are valid questions. However, then you can't nerf Congress in that way because they're able to.
I think that's why I think you would have a separation of powers problem if an agency, even if it's a vast agency wielding a broad panoply of powers, if one of those powers is the president's conclusive and preclusive authority, and the officers who are exercising that power are insulated.
So long as one person in the agency is exercising conclusive and whatever that means, that's enough.
So it's
whatever that means.
And I wouldn't just say person, I would say a principal officer. It's enough to generate a separation of powers problem. And what is the remedy for that problem, I think, is an analytically more difficult question.
What's the difference?
It strikes me, Mr. Agarwal, as I listen to this, if you go back to, let's say, the Education Department with which the Chief Justice raised, that the more realistic danger here is that we'll have an Education Department as authorized by Congress, by law, that won't have any employees in it.
For fuck's sake, I swear to God, Tammy, I'm gonna block you after this. I will explain this to you really quickly. We have a system of checks and balances and separation of powers. Congress creates laws, the executive enforces laws, and the judicial reviews law, interprets law. That's how basic government structure works. Now, Congress wrote the FTC Act. A president signed it in. I believe it was the other Roosevelt. Either way, he signs it in, right? So it's fucking law. And Congress created the FTC and gave specific removal protections. Whether you like it or not does not fucking matter. It's not about checking Congress. This case is about whether Trump can fire her.
Term. So, this is going to have longer term implications.
So absolutely, but let me make 2 points on that. First, there is currently no constraint there's currently no case that has ever held that Congress cannot give for-cause removal protections to principal officers serving to a single layer of for-cause removal protection for principal officers serving on a multi-member commission. And nevertheless, notwithstanding the absence of any such precedent
one of my mods
American
can
history,
get her,
we have not seen an epidemic of these problems. In fact, we haven't seen this problem materializing at all. But let me make one other point about the real-world danger that is imminent right now that we know will happen. And that is that if petitioners get their way, everything is on the chopping block. And we're not just talking about the FTC.
He's not wrong.
Counsel said
because
we're
this
not
case has a lot
right
of
now
implications.
The Federal Reserve. We're not challenging Article 1 courts, but there is absolutely no principled basis for carving those very important institutions out of their rule.
Well, you're right that the Solicitor General was pressed quite
this
legitimately about things like the tax court and the claims court, et cetera, et cetera. But I don't know that you can make the argument that the logic of his argument is going to cause these allegedly revolutionary results without being prepared to explain more concretely than you have the limits of your own argument. I mean, I could go down the list with you of the cabinet officers and ask you whether you think they could be headed by a multi-member commission whose members are not subject to at-will removal by the president. Shall we do that? How about Veterans Affairs? How about Interior?
They already conceded
Labor,
earlier that they're not
EPA,
trying to get rid of the
Education.
FTC.
What am I missing?
Agriculture.
So now you're saying they are?
Mr. Agrawal, are you prepared?
Well, there was a question there.
Yes, so I don't want to pretend to greater certainty than I have about the full gamut of statutory authorities vested in all those other departments. I will say that based on a very quick preliminary analysis, it appeared to us that the vast majority of executive departments wield at least some of the conclusive and preclusive authorities that this court has recognized in the past, including criminal, investigative, and prosecutorial authorities.
Still
and
going to
also
hold out on
authorities implicating
Kavanaugh,
national
but I would
security
say
and foreign
Alito,
relations. Now, that
Thomas,
is not to say,
Gorsuch
Justice
for
Alito, I
sure.
think you're absolutely right to say for a lot of those, you could
I had
probably
a little
take
bit
those
more
out,
faith
and
in
at that point, there's
Gorsuch,
going to be a
but
fair question about whether
I've been wrong
whether
before.
Congress and the president acting together
I'm not
could determine at
Goons.
some
I'm
point
doing my
that there
live
is a
here
need
because
for a
my
multi-member
bedroom
body
wasn't
of
affected
experts
by the
to
fire
preside
and my
over
Wi-Fi's
certain
back up
government
and my
functions. And what I would
hotel
say is,
are
I don't think that
assholes.
you should categorically rule out that possibility as a matter of constitutional law. And I can't sit here today and tell you that there's a distinction of constitutional proportions, for example, between the Department of Labor and the National Labor Relations.
Well, how about the post office at the time of Myers? How does your exclusive and preclusive theory account for Myers? How can it be that the postmaster at that time exercised exclusive Article II power, but a federal trade commissioner does not?
So I would say three things about that. First, the conclusive and preclusive standard does not have to be the sole and exclusive limiting factor. Second, there is a provision that Justice Barrett referred to in the colloquy with opposing counsel about the take care clause, and it is conceivable that at least in some circumstances, the take care clause might itself, not always, but sometimes, impose a conclusive and preclusive
also limits the ability of the board to be bipartisan.
For example, with respect to officers
now it's going
like
to be a
the Postmaster and Myers, who are
hyper-partisan
deemed
board, which can
possess
be more
purely
problematic
executive
because
functions, as
if you
this court
think Democrats
unanimously
won't
and
fire
Humphrey's
every
executive,
one of
and
these
Weiner
motherfuckers
unanimously
that Trump's
characterized
going to
the functions
appoint,
of the Postmaster
think
and Myers
again.
as purely and obviously
And I don't
just
want that.
executive.
I
So
like
that's the
stability
second-
in my
that's the second
financial
constraint.
When you
institutions.
answered Justice Alito
So if you're in
about
here
the
arguing
agencies
that Trump should be able to do
exercising
this, just
power,
realize when that
and
shoe's
thus
on the
there'd
other
be a
foot,
question whether
baby,
they could be made independent multi-member
they'll be
commissions.
just as petty.
Don't
That's
a
why
lot of
I'm
the
politically homeless,
now
because
independent
I have a
agencies
problem with all of
also
this.
exercise that kind of investigative power. At least from my experience, it's very hard to get into the weeds of this particular powers exercised by the FTC and distinguish
Kavanaugh.
it from some of the powers exercised by some of the other cabinet agencies that we traditionally think of as executive, or the FCC or the SEC. All of those seem to the FERC, NLRB, when you get into them all. So what's your answer to that?
So my answer is the criminal investigative authority is different, and certainly a lot of these agencies have civil investigative authority, including the FTC. As we understand it, this court's precedent just from last term in Trump v. United States, criminal investigations and prosecutions are in a different category, at least as a general matter.
I think that they may allow some of it, but they're trying to make it very narrow.
Is that there are certain functions that cannot be wielded even by traditional independent agencies, then so be it. That's the law of the land.
That's right. I'm sorry. Go ahead, please, go ahead.
Go ahead.
All right. I understand conclusive and preclusive
Gorsuch.
entirely, as we used it. When you're speaking about executive power, can the president control what's done in his departments? I get that. And criminal prosecution is a good example. I do not understand it as you use it. Why isn't it just as conclusive and preclusive to decide whether to bring charges?
This is an okay
under the
question. This is
FTCA
decent.
Act against somebody? Civil versus criminal. It's a conclusive and preclusive decision about enforcement decision of the power of the federal government against individuals across the country.
So there's a legal answer and there's an historical answer, and they might blend, Justice Gorsuch. And the legal answer is that we don't have any controlling authority that has ever held that civil enforcement as a categorical matter is the kind of thing that can never be vested in a multi-member agency that enjoys a modicum of insulation from political pressure. And we know that, for example, from this court's unanimous decision in Humphrey's Executor, where you had that kind of civil enforcement taking place, and a unanimous court, including all four justices justices from Myers said that's okay. And the kind of civil enforcement that was going on there, you had complaints being issued, you had cease and desist orders.
Cease and desist orders, but not lawsuits in court. They had to go to court. And,
so this is an interesting point, and probably the strongest point of the Trump administration is at the time of Humphrey's executor,
conclusive and preclusive decision whether to use
there wasn't
the
quite as much authority within the FTC in like sort of the power that they wield, and it's probably one of the better arguments they're making in this case. A lot of this has revolved around it. If I would have hardlined the specific text of Congress, had I been, but yeah.
And on the historical part, we have had all kinds of civil
all of them
enforcement
have asked
federal
questions.
statutes
Kelly
taking
Kagan,
place,
Sotomayor as
including
well.
just private statutes that authorize private attorney generals, as this court has recognized in many cases. So we have a long history and tradition of private actors wielding kind of enforcing civilly federal statutes. Now, I take the point that civil enforcement on behalf of the government of the United States.
That's not the executive power, but criminal actions is the executive power.
I would not say that.
That's what you're
I
asking
also
us to
No, I would
put
not,
all these to
I would not put it that
YouTube
way. I
as
would not say
well.
it's not
It's in my
executive.
link
And in
tree
fact,
if anybody wants to follow it.
Yeah, in Seola,
that'd be
this court
great.
said it's not only executive, it's quintessentially executive. And that's okay, because agencies like the FTC also engage in adjudicative activities, and that would be deemed quintessentially judicial, and nevertheless, they're not subject to plenary removal on the part of the judiciary. They engage in rulemaking that could be considered quintessentially legislative, and nevertheless, they're not subject to plenary control on the part of the legislature. The issue is not whether it's executive in some sense. The issue is whether it's constitutionally committed to the president's sole and exclusive discretion, and as a matter of history and precedent, we haven't gotten there yet.
So even some quintessentially executive functions, in your view, are not vested in the President of the United States?
I would not say that. I would not put it in this. I would not say that they're. Yes, I would say they're not.
You have to say yes to that based on what you've just.
They're not constitutionally committed to the person of the
president.
Thank you so much, everybody,
for the likes and the shares and the follows. Y'all are so amazing.
Just as much in Humphreys. I mean, didn't we have some lines in Humphreys that say, to the extent that it exercises any executive function as distinguished from executive power in the constitutional sense, it does so to discharge. It does so in the discharge.
Not tripping up as much as I thought he was. He's already made concessions.
So I thought that in Humphreys we recognize this idea that you could have an agency that's exercising legislative or judicial powers still engaging in some executive function, and that doesn't make it an executive agency.
That is exactly right. And on top of that, we have a lot of agencies over a long period of time engaging in all manner of civil enforcement of federal statutes, and yet we do not have a single example of any case from this court in more than 2 centuries that has ever held that a single layer of for-cause removal protection cannot apply to a principal officer of an agency wielding that kind of civil enforcement function.
And so I think that's like your real point. In other words, you're not asking for some sort of conclusive or preclusive rule. That's not your burden in this situation.
That's
you were just
exactly
saying
right.
That the way the law has been interpreted by the court here,
the Trump administration is asking you
reliance on
to say that he's absolutely allowed to fire
something like 90 years
anybody.
Plus. That's the background.
That's not their burden.
And so now it's up to the government and the Solicitor General to come in to suggest that there's a constitutional problem with that.
That is absolutely right. We have a 111-year-old statute that was enacted by the people's elected representatives.
1914 FTC Act.
Of the United States. It was unanimously affirmed by this court, and it's been followed by every single president since 1935 until the present. We don't need an abstract theory to tell us that the FTC Act is okay. It's the other side that needs to give you a really compelling theory to explain why, in our view, 200 plus years of precedent and history need to be abandoned. But in any event, by their own acknowledgement,
and it's
we're talking about the modern era of
letter
traditional independent
of the
agencies,
law,
which spans more than half the life of the republic.
Can I ask you about some other limits of your argument? So most of the independent agencies by statute must include members of both major political parties. Is that a constitutional requirement?
I don't think so.
Could Congress create independent agencies with, let's say, 10 or 15 or 20-year terms?
I do think at some point, Justice Kavanaugh, that if there is not sufficient
Don't make any concessions. Just be like, if that's what Congress did, that's what Congress fucking did.
This is important. Yeah. Why? You got to have a theory on that.
Yeah, absolutely. So there is a take care clause in Article 2,
God,
Section 3.
This is not the case, like I said, to be popping your cherry on.
Are operating within the purview of the executive branch, and they should be subject to constitutionally appropriate presidential supervision.
So do they have to turn over with each new president then?
So in the case of the FTC, I don't think
that's exactly what Trump is literally proposing, is that they would turn over with each new president.
20 years, constitutionally speaking.
I think our position is that the FTC, no matter what kind of rule that you articulate, would be okay, because we have the staggered terms, and presidents have the opportunity as a practical matter to influence the composition of the FTC. You start to get into more difficult line drawing problems if you imagine hypothetical scenarios where presidents, you have longer terms and maybe fewer officers, and maybe presidents in that circumstance don't have.
What about the chair? Usually the chair has been removable at will as chair by presidents, but that's been a matter of statute for most of these. Is that constitutionally required?
No. And we know that from Humphrey's executor, actually, because at the time of Humphrey's executor, the chair of...
I want to be so incredibly clear that literally what the Trump administration is proposing is saying, fuck what Congress said, fuck what they put into the act, and fuck what they put into the creation of this. You should say they can't do that because executive. That is a really brief synopsis of what the Trump admin is arguing. And this side is saying that's not what fucking Congress said.
And
do they have legislative power or do they not? That's the real question.
So you can imagine a situation, and I just want to give you a chance to deal with the hard hypothetical.
Matt, don't even get me started,
Congress and President are controlled by the same party, them creating a lot of these independent agencies with or extending some of the current independent agencies into these kinds of situations so as to thwart future presidents of the opposite party. And to Justice Barrett's point, I don't think we can just say, oh, that hasn't happened, so it'll never happen.
Absolutely. And I don't think that you should articulate a rule that categorically rules out.
So Kavanaugh seems to, at least if he's going to concede here, he gives vibes that he wants to keep this very narrow.
What would be the theory? I mean, that's what I'm getting at. There's, just picking something out of thin air. What is the theory?
They're very much picking at this.
Basis in the Constitution for that would be the Take Care Clause of Article 2, Section 3, which does require the president to take care that the laws be faithfully executed, and this court
I agree, Kelly. Barrett and Kavanaugh seem more conflicted. Gorsh, Thomas, Alito are gonna lick the Trump administration's ass.
of CLA law that discusses exactly the types of considerations to which Your Honor is referring. The designation
Robert's
of the chair,
he's always up in the air. He doesn't talk enough for me to know.
Influence the composition of the commission, budgetary tools. I think all of those the FTC has, and so we're on the right side of the line wherever you draw that line. But I guess
he's making an appeal to textualism and appeal to originalism because reconciling this is going to be a problem for them.
Political accommodation, and there's no reason to believe that process, which has been adequate for a very long time, will not be adequate in the future. But if it is, the court can keep open the possibility that there will be time enough to decide on new constitutional rules.
How do you answer the accountability theme, which I think is the theme of the other side, is that independent agencies are not accountable to the people. They're not elected.
In what?
As Congress and the president are.
But that's the thing, is that he in no way said that Slaughter was not accountable. I'm sorry, I'm pausing. I know that drives out crazy, but he in no way said that Slaughter wasn't accountable. He in no way made that postulation that there was inefficiency, neglect of duty, malfeasance, which are the three reasons you actually can remove her. He just said our vibes don't align. We're not on the same page, so you got to go.
Freedom of the press in this very case that talks about real dangers to freedom of the press, to individual liberty, to free speech rights that would result from saying that agencies like the FCC are all of a sudden subject to at-will presidential removal. And they discuss the history, just as one example, this precious First Amendment right that could in every meaningful sense be jeopardized if we abandon long-standing history and retroactively invalidate the independence of independent agencies. The last thing I would say, if I may, Justice Kavanaugh, in response to that point on political accountability, is that I think it would be a really unfortunate way to vindicate the principle of democratic accountability for this court to effectively invalidate. We're not talking about one
Kavanaugh's
or 5 or 10
making
or
a
even
vibe
15.
argument. I think he's probing
traditional independent
between the idea of
established by
unitary
statutes enacted
executive
by the people's
versus
elected representatives and signed into
the way
law,
we've
all
always
of them,
done it.
by democratically elected presidents. If it is really true that these kinds of for-cause removal protections, which after all authorize the president to fire commissioners just for good cause, if they really pose this fundamental threat,
literally Trump had to do was say, I don't think you're doing your job inefficiently.
Thank you, counsel.
He couldn't even
mentioned
do
Humphrey's
that.
executor quite a bit, and also SCOTUS law. The one thing SCOTUS law made pretty clear, I think, is that Humphrey's executor is just
I'm not
a
sure.
dried
He may
husk
be.
of whatever people used to think it was, because in the opinion itself, it described the powers of the agency it was talking about, and they're vanishingly insignificant, has nothing to do with what the FTC looks like today.
Good cause is inefficiency, neglect of duty, or malfeasance in office.
It was addressing an agency that had very little, if any,
that is the three
executive power.
specifications
And
that
maybe why
the
they were able to
FTC Act
attract
carved.
such a broad support on the court at the time. I mean, putting Humphrey's executor aside, what's your next good case?
We have 2 other cases in which the court has had occasion to assess the constitutionality of a single layer of for-cause removal protection applicable to a multi-member commission. And those 2 cases are Weiner v. United States and Free Enterprise Fund. In both of those cases, the court unanimously concluded that a single layer of for-cause removal protection does not offend the separation of powers, even with respect to agencies that were wielding what everybody today would consider significant executive authority.
Well, certainly Weiner
Roberts
is
notoriously hard to read
and does exercise significant authority, but of an adjudicative nature.
The fact that he's asking more questions does not bode well for me,
line from Humphreys, or an entirely different situation involving adjudicative authority that the court did not say in deciding Humphreys was
and that's his own rule.
A couple of responses.
Look at
to
how
that,
many
Mr. Chief
questions
Justice.
they ask
First,
specific
petitioner's
arguments.
Theory is based on the assumption that anytime you have an officer who is acting outside the auspices of Articles 1 and 3, no matter what kind of function
Thomas is
they are
usually pretty
discharging,
quiet,
what they are doing, quote, is
but he
and
likes to
must
ask the
be
first
deemed
question
an
a lot.
exercise of the executive power. And if that is true, that sweeps in the commissioners of the War Claims Commission.
Maybe.
It sweeps in
Roberts
the Federal
is
Reserve. It sweeps in the Court of Appeals for the Armed Forces. Their constitutional theory cannot be distinguished on that basis.
Well, what about the regarding them, as I think Justice Gorsuch was discussing at one time, as adjuncts to the judicial authority, which would be something that would cover the court, I
potentially
think,
just give some
Weiner.
sort of overreaching broad here, but
If
you do
this is a
think that
viable
we're going to see
distinction
some
to say that
change
there are
to
certain
this. That's my
functions that are
guess.
being performed that are of an adjudicatory nature and that some kind of exception should be carved out for that, then why not for the FTC, which after all does exercise adjudicative powers? Indeed, as this court explained,
Jackson also plays devil's advocate as well. It's a really good
FTC,
style of hers. I really appreciate
the
it.
FTC,
well, sure. Go ahead.
The FTC stands in the shoes of the district court. In such cases, it's doing exactly the type of thing that district courts do. It's finding facts and reaching conclusions of law.
Yeah, but it does a lot of stuff in addition to that Weiner, the court in Weiner did not do. And
this
many
is
of these
aside
other
for
entities
slaughter
that you've been talking about with exercise judicial responsibilities might properly be considered adjuncts to the judicial power in Article 3 as opposed to purely executive power, which was not at issue in Humphreys or Weiner.
2 responses to that, Mr. Chief Justice.
Sure.
In Weiner, the claims commission members were making final and unreviewable determinations with respect to claims for compensation, and they were getting no judicial review. That was final determination, but the more important point is that in Free Enterprise Fund, there was all manner of executive authority that was being wielded by we're not talking about the 1935 FTC, we're talking about the 2010 Securities and Exchange Commission and the 2010
He said y'all already
Company
looked at
Accounting
this.
and Oversight Board. This court characterized the board's functions as involving enormous power
He's
to regulate an
better.
entire industry.
To be
Nobody
fair,
would say
he
that
did
was not
clerk for
executive. And nevertheless,
Alito.
the court unanimously
I wanna
concluded
say it was
that a
Scalia
single
he
layer
also
for cause
clerked
removal
for.
protection, exactly what we have here, is
So
constitutionally
he
permissible.
knows
On
who
top
they're
of
gonna
that, we
ask.
don't again have a single case that has ever struck down the kind of removal protection that we have here in more than 200 years.
Thank you. Justice Thomas?
You used, when I asked you, or when a number of us asked you about making some of currently the executive branch cabinet level agencies, multi-member agencies, you resorted to the functionality of the current agencies such as Commerce as precluding that, or at least as being a basis for not doing that. Now, moving the other direction, could you functionally, you say that from a functional standpoint, the FTC is not an executive branch agency, and you listed some of its functions. Could Congress convert the FTC
best guessing
to a
based on the
single member
question,
head with the
they're
same
going to tier
protections?
this is going to be
Because
more
it
narrow,
engaged in
and
discharging the exact same functions.
I don't think they're going to
No,
gut
under this
Humphreys,
court's
but I
precedent.
certainly
Could they,
feel
under
like
the
there's going to
logic
be some
of your
changes.
argument?
No, we accept seal of law as not only the
Kelly.
law of the land, but as being correct.
So
And we embrace its
what's the
reasoning.
limitation? Your argument was functionality before, not necessarily precedent. And I'm interested in why would the FTC functionally be any different
One of the first things he
as a
mentioned was
single
precedent.
member head than it is as a
I've met
multi-member
Anita Hill Lawless.
agency.
It is because seal of law is correct, not just because it's precedent, but because it's correct to hold that there is a particular danger to individual liberty that is posed by the single director, highly anomalous circumstance that had no foothold in history and tradition, and that vested a massive quantum of power in one person who was not directly accountable to the president.
I don't understand why that's any different from a multi-member agency.
For all the reasons, Justice Thomas, that this court explicated in seal of law itself, and in particular in parts 3C1 and 3C2 of the decision, where
He
the court
said,
talked
"Check
about basically
that,
two
bitch."
categories of considerations. One is the foothold in history and tradition, and the second is whether the configuration of the agency poses a problem for structural separation of powers principles. And in both of those, the court explained, and elsewhere throughout the opinion, the implications for individual liberty of taking massive amounts of governmental power and putting them in the hands of one person who's not accountable to the president, as opposed to where you have the multi-member structure. As a practical matter, there needs to be consensus, there needs to be deliberation, there's a safety valve in terms of dissenting opinions can be issued, and that can provide an alert to the public that something is going.
I don't see why it's crazy that the president should just have to show some cause here. They made it easy. They gave you three things: inefficiency, neglect of duty, or malfeasance. Any of that, had he just written it in the fucking letter, would have been fine.
Adhere
I swear to
all of
God,
its
I'm losing my
precedents and to give
fucking
effect
shit.
to the collective wisdom and experience of all three branches of government. On the other hand, petitioners are asking you to abandon precedent after precedent after precedent. A lot of precedents would go south
he's
if their
clocking
constitutional
them.
theory is correct, and a whole lot of history and dozens of institutions that have been around for a long time that have
And
withstood
thank
the
you
test
all
of
so
time,
much for
that embody
sticking
a
out with
distillation of
me.
human
I know
wisdom
I'm
and
a
experience.
loudmouth,
All of
but
those would go south.
I mean well.
Justice Alito?
To follow up on Justice Thomas's question, suppose that
Alito.
suppose that the FTC did not have that the members, commissioners did not serve 7-year terms, staggered 7-year terms. Suppose there was not the requirement that no more than 4 be members of a single political party. Suppose that they served very short terms. Why does it matter that it's a multi-member body as opposed
it
to a
matters
single-member
because
body
you
in
want
itself.
consistency
What is
in
significant about
financial decisions. You
The
want
significance
bipartisan boards.
is the distinction for purposes of individual liberty, the threat that is posed to individual liberty by single-headed agencies that are not accountable to the president. That, as I understand it, Justice Alito, is the logic of this court's decision in seal of law, and we recognize that intelligent people of goodwill can disagree about that.
Seal of law didn't have to decide the question that's before us here.
I don't think he's making up new rules.
There were two
He's
FTC
just
commissioners
asking
and they served
stupid
one-year
questions
terms.
like, what's the
And you
point
would
of
say,
this?
well, that's okay, but
Because we don't need an overarching agency
there's a
fucking
difference
with our
between that
holy
and an
financial
agency that's headed
institutions.
by a single
That's
person.
why Congress
Making the
created
terms
the
shorter,
fucking
in
FTC
my view,
the
would not
way
raise
that they
constitutional concerns because that would
created
only
it.
increase presidential opportunities to influence the composition of the agency. Reducing the number of commissioners might be a different type of situation. I'm not aware
Says
of any
Alito
two-headed
and Slaughter's
agency that has
attorney.
ever
I can't remember
been
his name.
created in
Hold
the
on.
modern era or throughout American
wrote it
history.
down.
Well, okay, what we're looking for are conceptual explanations for the distinctions you're drawing. But let me move on to something else. Suppose the Department
Arwal.
of Justice were
It's Amit
split
Arwal.
into two parts. One part has the authority to enforce the criminal laws, and the other part has the authority to enforce civil laws. Could the civil component, could Congress put at the head of the civil component a multi-member commission with removal protection?
That's actually a
Justice
decent
Alito, there is
question.
the logically antecedent question with respect to any removal protection.
I can.
Of whether Congress has constitutionally enumerated authority to enact the protection in the first place. And as has been suggested in prior colloquies, the relevant source of constitutional authority would appear to be the necessary and proper clause in terms of attaching removal restrictions to a federal office.
We're
that is
working on
created
2
by
hours
Congress.
now. They're usually
I
about
don't
90
think it's
minutes.
obvious
Some wrap up quicker.
that you
But
would-
this
you
one
would
I knew it was going to
comply
stretch.
with all the strictures of the necessary and proper clause ex ante. And so it's not obvious that Congress could do that. And what we know for sure is that Congress has never tried to do that.
Well, I know, you keep answering, it
question,
hasn't been
Wallace. I
done,
think
and it's
there
not
is.
going to be done in the future.
But it may be
I-
the only case
I
for
want to
today.
understand the limits of the principle that you're asking us to accept. So you're not, you cannot say, no, that would not be permitted for this reason.
Well,
The best you
it's the
can
only
say is
case
that
of
it
the
might
day.
not be necessary
They already
and
knew.
proper.
if you wanted, that is one source of limiting principle for sure. But also, our argument is predicated in part on a long historical tradition pertaining to what
Okay,
are
I
called.
understand.
It's
the
not even a historical
the
tradition.
historical
It's the
argument. That wasn't
literal
what my question was
text
getting
of
at.
the
All
of
of the
the
civil
act.
enforcement laws, all of the civil laws that are now enforced by the Department of Justice were enacted by Congress under one of its enumerated powers. Let's assume that they were all constitutional. So the question is whether it would be necessary and proper to the enforcement of those given the understanding of necessary and proper, to entrust that to a multi-member commission as
Alito
opposed to a
just makes me
single
wanna punch him in the
officer like the
face.
Attorney General. That
Like,
would be the
low-key,
question.
I don't
think
like
so. And
love
what I was trying to
anything
get at
about
before
Clarence
is
Thomas.
not just that there's a historical tradition,
But
it's that the
his
historical
judicial
tradition we're
style,
invoking
I'm
is for
kind of
what are called
fond of.
traditional multi-member
Alito's just a
regulatory
lapdog.
commissions. And those
Like, for real,
historically have never
people
involved
complain about the
pure-
other
just
justices.
purely executive civil
Alito is the
enforcement. They
biggest
involve a
Trump
blend
taint liquor
of
there is.
lawmaking, adjudicatory, and enforcement actions.
And I'll
where the
take that to the
enforcement
bank.
authority is deemed to be reasonably ancillary to the other functions. So the kind of hypothetical that you're positing, Justice Alito, I think it's an absolutely legitimate concern, but the historical tradition that we are drawing on for purposes of our constitutional liquidation argument would not
And there's
require
nothing
you
wrong
to
with like
affirm the
examining
constitutionality of
sort
that
of
kind
these
of
like
highly
outer
unusual
rim like
structure
type
that, as far as I
questions
know, has
or
never been
looking for
attempted
like
before.
On the question of,
where's their problematic overlap.
Giving
I just
the members of a multi-member commission
His voice
longer
just
terms of
agitates
office. So
me.
here we have 7 years. What if it were increased to 10 years? What if it were increased to 15 years and so forth? And the principle that you
Oh
would
my
have
God,
us
if
apply
they
is whether
fucking
that
they're gonna
longer
waver
term
on this,
of
you
office preserved.
They're going to make a
adequate
concession here, and
supervision?
it's going
Is
to
that
fuck their
your answer
case.
to the question?
Because
That is one potential limiting principle. I
We
know
would have
the
to
only
in
answer should
each of
be,
those
that's what
in every
Congress
case in which that
said.
would be involved. We would have to
Fuck that
determine, do I think this preserves adequate presidential supervision?
our primary submission to you, Justice Alito, would be that it would not be the burden of the court to develop ahead of time heavy-handed constitutional rules that would try to make constitutional distinctions between, say, a 7-year term and a 9-year term or an 11-year term. Those don't appear to us to be distinctions of constitutional proportions. Members of the Federal Reserve do have substantially longer terms than, say, FTC commissioners, and nevertheless, petitioners don't seem to have a problem with members of the Federal Reserve enjoying statutory removal protections. But our position is that the court should recognize that these are really difficult line drawing problems, and the way that has historically been resolved is through the political process. And the political process is up to the task of dealing with this problem.
But you wouldn't say that we leave it completely. Would you say we leave it completely to the political process? So that at no point in the extension of these terms would we say, oh, there's a problem. I thought you were saying there is a test. And it is whether there's adequate presidential supervision. And if that were challenged, we would have to decide. We would have to exercise our judgment about how much presidential supervision is necessary to satisfy constitutional requirements.
Absolutely. The court should not relinquish its authority to establish judicially enforceable outer boundaries in this context. I just don't think that you're going to have to do that anytime soon, and you might never have to do it, but you should absolutely not relinquish your authority to do it. And there could be hypothetical scenarios in the future. That's a big point in this case. There's an arrangement that just palpably does not guarantee adequate presidential supervision.
How far does this judicial authority go?
Against the real world chaos and disruption that will be caused by taking.
Okay, one other question about the.
Oh, you don't want to hear about that part.
Your argument would lead. So to go back to this issue of the various departments and whether it would be permissible for Congress to convert them
Y'all can tap the screen. It helps so much. Thank you.
Agencies headed by multi-member commissioners, by multi-member commissions with the members protected from plenary presidential removal authority. The test would be whether some limit on permissible, limit on exclusive and
it's not CAB, this is Alito.
Activities was exceeded.
Our primary.
Do they go to, if they're exercising any power that is exclusively and conclusively the president's, are they exercising too much of that? That would be the test in going through these departments?
No. I think if they're exercising any power that is conclusive and preclusive, then you have a separation of powers problem. That's the solution to which is not necessarily to strike down the entire agency or even to eliminate the for-cause removal provision. It creates an analytically distinct issue about how you remedy that violation. But I think any conclusive and preclusive power that is vested in an agency that is not sufficiently accountable to the
I'm going to be real. I think, okay, I'm going to stick with my tiering.
Scintilla would not be enough, but now you say a mere scintilla would be enough.
I think we're going to see something similar to the layout of the immunity ruling. If it's this, then it's this. If it's this, then it's this.
A multi-member agency is vested with the president's conclusive and preclusive
I'm going to make a bet on
and it
that.
is insulated from at-will presidential supervision. That is a separation of powers problem.
It does 200 things, and one of the 200 things involves the exercise of an exclusive and conclusive presidential power. That would be too much.
That would be too much with respect to that power, but maybe the solution to that is to sever out that power and not to strike down the entire agency.
Oh, that part.
Justice Sotomayor?
Counsel, Sheila law involved the CFCP, and it relied very heavily on, focused very heavily on the novelty of the CFPB structure and the fact that it was a historical anomaly, correct?
Absolutely. It was an anomalous structure that was deemed to pose a significant threat to individual liberty.
All right. That's not the case here because we have a precedent of longstanding that says this is okay. The chief asked a question about whether the additional powers the FTC has gathered create a different situation.
And it's a good question. That's one of the strongest arguments the Trump admin is bringing.
Outlined very.
But I agree with the lawyer's concession that you carve out that it conclusive and preclusive authoritative powers
are the same powers of today, correct?
That is correct.
And there is one power that I've identified that might be different, and that the FTC's cease and desist orders have now binding effect immediately, correct?
I believe that's correct.
So I think your point in response to Justice Alito is, if there's a power that the FTC is wielding now that trenches inappropriately, the answer is not to do away with the for-cause removal, but to eliminate that power, that individual power.
That was a banger.
Correct. And
that part.
An authority that is cited by petitioners in their reply brief, Barr v. AAPC, supports that proposition.
And so that should be the answer if there's been a difference in the powers or an expansion of the powers inappropriately.
That is our position. Yes, the parties have not briefed severability at the merit stage of this case. And in the event that the court wants to reach that question, you might consider either supplemental briefing or remanding to the district court to decide that issue in the first instance.
Thank you, Counsel.
Justice Kagan?
Remand, yeah.
Mr. Eckerwell, it seemed to me that when you were talking to Justice Alito, you had more to say about this question of comparative risks and how we should balance the two kinds of risks and what we should be thinking about now. So I wanted to give you a chance to say that. But
I'll try, Everett.
And within whatever you want to say about that topic, I was wondering if you could comment. A lot of these hypotheticals have been about, what if Congress structured an independent agency like this or like that. Most of these independent agencies, Justice Sotomayor is right that the CFPB was anomalous in this respect, but basically, like, the vast majority of them all use the exact same structure, or if not exact, near exact same structure. There are little variations, but they're all set up with bipartisanship. They're all set up with a chair that does have some greater control and that is more controllable by the president. They're all basically set up the same way. So all of these hypotheticals about what if Congress did this, I'm wondering if you could comment in your discussion of comparative risks about how we actually why it is that we actually have just never seen that.
I think it's because the political branches have learned from experience, and experience is the great teacher. There's an insightful discussion of the history and tradition surrounding traditional independent agencies and the separate opinion in the PHH case that has been cited extensively by the parties, and that explains that the structure that the political branches have come up with honors and gives effect to our constitutional values, as we explain on the very first page of our brief. We think that the political branches have done a good job of learning.
The political branch is Congress, which is made up of both Democrats and Republicans, who are aware that neither Democrats nor Republicans will control the forever, and are structuring these systems with that in mind.
I think that is exactly right, Justice Kagan, that there's an appreciation and an understanding that folks in power today may not be in power tomorrow, and you want a structure that will be able to withstand the test of time. The other kind of interesting thing about this is that it's not just Congress. It's Congress acting together with the president every single time. In the case of the FTC Act, the act has been amended time and time and time again since this court's decision in Humphrey's executor. Presidents are signing all of those bills into law. They are supporting the FTC in a myriad of ways. They too have read the vesting clause of Article 2, and they too believe in preserving executive power. It is simply implausible to say that presidents have been supporting these traditional independent agencies now for more than a century and a half, and even from the first Congress, George Washington signing into law the Sinking Fund Commission, the Revolutionary War Debts Commission, the Mint Commission. It is absolutely implausible to say for the entirety of American history, presidents of the United States have been complicit in giving up a vital executive power that is, according to petitioners, indispensable to their constitutional duty. The better answer by far is to say that presidents have understood and appreciated that vital interests of the American people can be served by having constraints on the exercise of power. That is a really important part of our constitutional tradition, and that is what petitioners are putting at risk.
You mentioned some of the early history, and I think I want to give you a little bit of a chance to talk about that because we haven't. You know, when I was a young lawyer,
she said, "I ain't got anywhere to be."
Theory
Let me know.
Got its start and got its legs. There was a pretty simple version of the history, and that drove a lot of the early discussion of the unitary executive, what was wrong with Humphrey's executor. What have the historians been telling us more recently about that sort of early understanding of the history? And you know, like
this is an appeal to originalism, everybody, and Kagan is reeling it in good.
There's an insightful discussion of this in an essay authored by Professor Nelson that we have cited in our brief and that cites recent historical scholarship.
That's right,
and there's also many amicus briefs that have been submitted in this case, which basically affirm that there is a rich body of recent, including
so if you're not aware of this, there are there's more, but there are three really like distinct kind of judicial styles. There's originalism, textualism, and activism. Now, what you would term liberal justices tend to practice what they say as activism, though it's not all activism. A lot of these styles work in tandem, but originalism is an appeal to how did they mean it when they set this up?
Exercising any significant governmental authority. We know that from the First Congress and the Sinking Fund Commission, the Revolutionary War Debt Commission, the Mint Commission, and I think there are some 10 other commissions, for example, that are discussed in Professor Norris's
textualism is what the fuck does it say? What does it mean on its face? But textualism, originalism, and even activism sort of, they all kind of weave together.
The other side's not doing that. They want you to give a maximalist interpretation to, for example, the decision of 1789, which we agree settled the question of whether the Senate should be able to interfere with presidential removals. But everything else, as Professor Nelson explains, as many other scholars have ably explained, is highly contestable at a minimum. There's actually a lot of historical evidence that goes the other way. That is all the more reason for this court to be cautious and developing heavy-handed constitutional rules that, one, don't have a clear basis in constitutional text. We absolutely accept this court's precedents that interpret the vesting clause of Article 2 to establish a general default presidential removal power, but it cannot be said the constitutional text clearly delineates the boundaries between the president's power and Congress's power.
It wasn't Alito and Scalia, it was Alito and Kavanaugh. He clerked for Alito and Kavanaugh. So he knows how to make this appeal to a sort of like originalist sensibility.
That significant governmental authority absolutely could be vested in commissions that were not subject to
originalism and textualism often work hand in hand, but textualism can work with
presidential control. And in fact, in a lot of respects, as the scholars have explained, those early commissions were actually substantially more independent than modern day administrative agencies. For some of them, the president couldn't even appoint. He couldn't even decide who would be on the commission, as, for example, with respect to the Sinking Fund Commission, where you had the Chief Justice and the Vice President were, by operation of law, installed on those commissions. So those commissions were, in a lot of respects, much more independent than modern day traditional independent agencies.
Justice Gorsuch.
I just want to explore, just for a brief minute, I hope, your scintilla of conclusive and preclusive power theory.
Oh, for fuck's sake.
You agree, I assume, the
Gorsuch
president
is really
vested
like
with
crawling
all
up my ass at
power.
this one.
Yes.
You agree that he has a duty to faithfully execute all the laws.
Yes.
Civil and criminal.
We agree that the Constitution imposes on the president a duty to faithfully execute the laws.
All the laws.
Well,
all the laws.
There's some laws he doesn't have to. That'd be news to our friends across the street.
The take care clause is a duty, and it is also a power, but the text of the clause does not provide that the president must have at-will presidential.
I didn't ask that. This is, does he have a duty to faithfully execute all the laws?
We know from
yes or no?
I would say no, in the sense.
Oh, fucking Jesus! No, don't do this shit.
I want to make sure that I'm answering the question.
I told you, Goose. I called it.
Execute all the laws. The answer is no. Why?
So he can't break the law for sure. For sure. Does he have to be vested with statutory authority to actually enforce directly enforce
Called it.
or to exercise.
I'm not asking whether he has to bring the indictment. I'm asking whether he has a
Fucking
duty to
called it.
faithfully execute the laws.
I think the president does not, under both history and tradition, have to have plenary power of supervision. But in the case of the FTC, he does have some power of supervision, including if there.
It was such a simple fucking question. Answer yes and move on. When you concede that point, your argument is breaking apart. I'm sorry. I said what I said. We'll see where he goes with this. I'm not impressed.
It's a demonstrable, palpable violation of law. The president could absolutely fire a commissioner of the FTC under the plain language of the statute.
So the answer is no, I guess. But you say that he has to have.
Mind you, the FTC Act, written by Congress, prescribes that you can fire them for malfeasance. What were the other ones? Sorry, I keep freaking blanking out when I'm trying to do this, so I apologize. Inefficiency, neglect of duty, or malfeasance. That's a law. It's
Off of
Bro, you're losing your own argument. You've already conceded your own argument when you do that shit.
I had understood the executive power, and he has preclusive authority of that. But this line, I don't know where it comes from.
You're
and I'm wondering, I'll be honest, I'll put my cards on the table. Maybe it's a recognition that Humphrey's executor was poorly reasoned, and that there is no such thing in our constitutional order as a fourth branch of government that's quasi-judicial and quasi-legislative. And maybe you're trying to backfill it with a better new theory that it self-recognizes that we've got a problem.
The theory that we are referring to, Justice Gorsuch, as we understand it, is not just based on this court's recent decision in Trump v. United States. It goes all the way back to Marbury v. Madison, and Marbury does not use the term conclusive and preclusive, but it absolutely says.
And neither does Humphreys. It uses quasi things.
It talks about the distinction between
Gorsuch is really stuck on the quasi
president's powers in the constitutional
in Humphrey.
sense. And executive power in the constitutional sense, and it actually cites Marbury v. Madison for that.
Oh, sure, I would hope it would.
For that proposition, and Marbury itself distinguishes in the context of removability of federal offices.
I guess I'm just wondering: are we going to get if we take your theory to backfill Humphreys and go down this road?
No, you can't just say we don't vibe and fire people. At least according to the act from fucking Congress.
Not as I understand it from Trump v. United States, but as you understand it, what powers are going to fall in and what going to fall out? Are we going to have just as much litigation over that as anything else we might do in this case?
I don't think so. We've had this modern era of traditional independent agencies for a long time. We haven't had any precedent ever striking them down, and this court has not been, as far as I know,
thank you for the likes and the follows. Y'all are so amazing to stick this out with me. I appreciate each and every one of you so much.
We have pretty much unanimity among courts that traditional independent agencies are fine. To go back to
we haven't had a lot of litigation over Humphreys and its limits and its boundaries, and I mean, seal of law, you invoke it as a great decision. We've had a lot of litigation.
We do invoke seal of law as a great decision.
We're always going to have litigation over the separation of powers, aren't we?
There will always be litigation, absolutely. But the point is that this court's precedents affirming Congress's authority to work with presidents to create traditional independent agencies has not generated any significant problems, still less insurmountable problems.
Thank you.
Justice Kavanaugh?
Try to tick through a few questions here. On Justice Alito's questions, you said independent agencies do rulemaking, enforcement, and some adjudicatory powers as well, but so do the traditional cabinet agencies do all of that too, or at least most of them do. So I'm not sure that helps you distinguish the independent agencies from the traditional executive agencies on the earlier questions, but I'll just leave that. You said you agree with all the court's precedents. That includes everything in Myers.
We agree with the holding of Myers.
Do you agree with the opinion in Myers?
No.
Thanks, affordability.
A lot of the reasoning in Myers went too far, and that was part of what the court decided in Humphreys.
On the text of Article 2, we haven't talked a lot about the theory by which you get to the other side's position from the text. The first 15 words, the executive power shall be vested in a president of the United States of America. For the president to exercise that power, he needs subordinates. For him to and he needs to be able to supervise and direct the subordinates. And to supervise and direct, he must be able to remove those officers at will. This is the theory. Otherwise, and this is what I want to get your answer to, otherwise a subordinate could ignore the president's supervision and direction without fear, and the president could do nothing about it. You agree that's the implication?
But then that would qualify as neglect of
The
duty.
subordinate could disregard the president's
That
instruction.
would qualify as
and then in
neglect
some
of duty, which is
circumstances, the
a
president could do nothing
specific
about it.
reason
Yes,
you
in
can
some
fire
circumstances,
somebody
but not
per
under the
this
FTC
act.
in the modern era
And-
of traditional
and
independent
a
agencies,
lot of
if there was
the other
anything
ones
like
set up.
malfeasance, if there was neglect of duty.
Malfeasance?
So that would be associated with law breaking, as Professor Manners discusses in
It's like
her
I can make
brief
his
on the
arguments
INM
for him.
standard.
But generally, if the president says, I wish you'd pursue a more aggressive enforcement policy, and the head of the agency says, I'm not going to do that, there's nothing the president can do about that, right?
If it's just a matter of enforcement priority, that's right. And
Or
that's
I would want you to issue a new rule in a particular way that does a particular thing, because I think as president it would be better for the American people, and the agency head says, I disagree with that, I'm not going to do that. You agree that that's
part of being
okay
an
under your
independent
theory?
agency, though.
That is okay under our theory. That's the judgment of Congress and the president. And as was pointed out in Ray Aiken, and as we've explained in our brief, this court's precedents don't stand for the proposition, Justice Kavanaugh, that we have to have those arrangements. They just stand for the proposition that the people's elected representatives in Congress and their democratically elected president, in appropriate circumstances, can come together and decide that vital interests of the American people, including preservation of liberty, and I don't think we should forget about that, including
I agree.
that can be
Like,
effectuated
remember
by
when
having these
Trump
multi-member
pressured
commissions.
all of them to
Two
like cut the
real-world
interest
questions are,
rates, and we
you've
were
mentioned
headed towards a
many times,
recession?
you just go to Congress
And then
to fix this. Well,
we also
once, the
ended
power's
up with
taken away
COVID,
from
which
the
made shit
president,
worse.
it's
Shit
very
like that.
hard to
That's
get
why
it
it's
back
problematic.
in the legislative process. Kind of the flip side of what we were talking about in the tariffs case, because the Congress, the real world of this is the independent agencies shift power from the presidency to the Congress. Everyone recognizes that Congress has more control over the independent agencies than they do over the executive agency. So Congress doesn't want to give that up. It's hard for the president to get new legislation passed that would, for example, convert an independent agency into an executive agency. Do you have an answer to that real? I mean, I think just leave it to Congress ignores the reality of the legislative process and Congress's desire to keep that power that they have had, that most people have recognized, over the independent agencies. That's a theory out there. I just want to get your response to that.
Yeah, I have two responses to it. One is that I don't think it's an accurate characterization of what's going on to say that Congress is aggrandizing its own power at the expense of the executive. I think, in fact, exactly the opposite. And a lot of these agencies...
That famous quote, the independent agencies are ours.
I mean, to be fair, cutting
Congress,
interest rates, I think that's more the Federal Reserve, but either way,
provision from the very first version of the Act provides that this Act is all about defining unfair methods of competition in commerce. Full stop. How do you know what is an unfair method of competition in commerce? The statute doesn't say. It delegates that congressionally, constitutionally enumerated authority to an agency that the president has all kinds of supervision and influence over, and what is happening in
much less than the executive agency. I understand your point there. I think I got it. Your brief refers to regulatory stability being a virtue served by the current overarching regime. I don't think a lot of the regulated parties really think stability has been a virtue.
Based on the time alone, Noel,
because it goes back and forth when the agencies shift power.
I don't know that they'll gut Humphrey's executor, but I certainly think that there's going to be
So can you address why you think, and this is relevant to the stare decisis factors, I think, why you think regulatory stability is
what they haven't talked a lot about is the second question presented is this sort of like, can the judicial
that comes from this court's decision just last term in the Chevron case, where the court said you can have a lot of regulatory instability if every single time a new administration comes into office, all of a sudden everything can change. Now, that is a problem on steroids if petitioners get their view, because
they're talking a lot about
to change.
this concept of, is it a unitary executive?
Everything the agency has been doing is
Are
wrong.
they
Public reliance
is this part
on
of the executive
stability
branch? They're
presupposes
probing that a
this is
lot
the whole point
more.
of the staggered terms requirement of that this court explained in detail in Humphrey's
I
executor
agree.
that the whole
I know,
point
I
of this
agree.
structure is to guarantee a modicum of stability that private regulated entities can depend upon, and that is jeopardized by at-will presidential removal.
Two more quickly. Hopefully, you've used the phrase chaos and disruption if you lose, and don't strike down the entire agency. I think you used that phrase. I don't think that's what would happen if you lost, and I think you would agree with what I'm about to say, which is if you lose on the merits, the proper remedy is simply to sever the for-cause removal provision, not to get rid of the FTC. Do you agree with that?
I agree with part of it, but not all of it. The remedy is not to get rid of the FTC, but I think there's an analytically difficult question about whether the
Chris,
proper remedy
to
would
some
be to sever
extent
the
he
for-cause
does, but
removal
since this
provision
is
as
an
opposed to,
agency
depending on the
that
nature of the ruling,
was created with a
maybe one
level of
isolated power
independence,
that is deemed to be
it's more
quintessentially
problematic
executive and
in
that generates the
this
separation of powers
circumstance. Now, if
problem.
it's
Okay,
just
last,
like
sorry about the length of this, but
his
this is
chief
important.
of staff,
Last, you said
fuck
Congress
yeah. But
as
this,
a tradition,
not
they
so
won't
much.
depart from it. But the last 10 years, we've seen two examples of first a single-headed independent agency and separately a double for-cause removal provision. So I don't think the idea that Congress is just following the model that it's used before is really sustainable in the face of those two experiments that we've seen in the last 10 years. That's just a comment from your point about, oh, there's a model and they just follow the model.
It is not an absolute
yeah,
rule,
that's my
and
problem
there may be
ever, is
times
that
when the political
legislatively
branches
they created this, and I
depart
think
from an
really
established model,
Kagan and
when they do
Sotomayor
so
kind of
in
hit the nail on the
constitutionally
head.
problematic ways.
That
What
if
we
they
know from
are
recent history is that
exercising
this
this
court
sort
will
of
be there,
broad
and there will be
executive
time
purview,
enough to
that
decide those
the
questions.
solution
All right,
is
thank you
to
for your
sever
answers.
that,
Justice Barrett?
not sever that you have to
I
have a
wanna
cause to
just
fire
ask
them.
a quick question about history.
Because
Justice
Congress
Kagan was
prescribed
asking
that you have to have
about
cause.
New scholarship that historians have identified, which you say shows that independent agencies has a longer pedigree than maybe some thought originally. But do you concede that the first statutory, anything that looks like a statutory removal restriction, like the inefficiency, neglect, malfeasance, appeared in 1887 with the ICC?
I don't know if it's the first, to be honest with you, Justice Kagan, Justice Barrett, I'm
Oh,
sorry.
I don't
But
know is
what
never
I
a
would say is
question.
that as to the early
That's never an
commissions,
answer
I
to
think
a
that
question.
factor actually cuts the other way because there was no provision authorizing presidential removal.
I don't
for
know.
some
I think
commissioners.
you
That's
sort
our
of
point. You
tanked
had
this
commissioners like the Chief Justice and the
with
Vice
the
President
Gorsuch
who were
answer of
appointed by
like,
statute,
does he
and the
have to
president
enforce
couldn't
all
remove them
laws?
under any
Well,
But
circumstance.
they
no.
were 2 of 5, and it could remove, he had
I'm gonna be honest.
unchallenged authority to remove the other 3 who served on that commission.
That-
I mean, and there's silence. I mean, there's not the inclusion of statutory removal restrictions. You didn't really see that until the ICC.
They were understood at the time to be for the officers like the Chief Justice and the Vice President on the Sinking Fund Commission, for example, to be completely insulated from presidential removal. And it wouldn't make any sense for the president to be able to remove them from the commission. That was not the understanding at the time, as has been ably set out by many historians. But here's the bigger point, is that those commissions are in a lot of ways much more independent than modern day independent agencies. And petitioner's theory is based on the idea that any
I know
time
this is like
these
not
commissions are
everybody's
exercising
favorite take of
significant
mine.
governmental
I actually
authority,
kind of
every
like
single
Amy Coney
commission
Barrett.
member
Do I agree
must
with
be
all of her
subject to
decisions?
at-will
Fuck
presidential
no.
removal. And in that respect,
I like
your
her as
theory
a
cannot be
justice.
squared with founding era
Okay, but
practice.
counsel, the sinking fund had the Secretary of State, Treasury, and the
Remind me
AG, and
later,
there's no
Angie,
dispute,
I'll
even under
explain
your
why.
theory, that the president could fire those 3. So sure, the Chief Justice and the Vice
I
President, but he could
appreciate
very
people
easily
that have
take
consistency in their
control over the fund.
judicial
Also,
style.
we distinguish that in Collins. I mean, it seems to me that
It's a
these
throwback
early
to
examples
Scalia.
had very, very limited authority. I mean, the Mint, or the Revolutionary War Debt Commission, there were no statutory removal restrictions, and all it did was settle accounts between the United States and individual states after the war. I mean, there's nothing that looks like the FTC at the time of Humphreys, or certainly not today. You have to concede at least that.
Yes, and two responses to that. I think it's a fair observation, but First, for the Sinking Fund
But
Commission,
then you're
for example,
questioning
maybe it
what
didn't wield the
authority
broad panoply
Congress
of authorities
has.
of the FTC.
I think
That's
this is
fair enough.
really
But
hitting on a
Alexander
broader
Hamilton thought that it was
question of
absolutely indispensable to the health of the
what
national economy.
can Congress
that this was
actually
about
do?
managing the public debt. And he thought that it would implicate the nation's stability going forward. That's why they thought this governmental function should be vested in this multi-member commission. So it was not something that was deemed to be insignificant by any stretch of the imagination. But one more point on the difference between the 3 members and the 2 members. We have real world evidence. This is not an abstract thing. We have real world evidence of Chief Justice Jay, I believe it was, who could make
should be
the
coming up on
dispositive vote
Jackson
difference in
soon,
terms
and
of the
hopefully
Sinking
she
Fund
doesn't
Commission
ask
when they
8
make a
billion
decision
questions,
that the
and then
president's
we'll head
cabinet
to
supports,
rebuttal.
when they make a decision that they don't. And so the fact that there are some members of the commission who are conceitedly not removable
Yeah,
at
Angie,
will
that's
by the
kind of a
president,
bigger question I
that just
have
makes
here
our
is,
point that the first
are we
president of the United
questioning
States
sort
and
of
the
the
first
law
Congress
and
emphatically
agency
rejected the
creating
constitutional
power of
theory on which
Congress?
petitioner's position
And then
is
are
predicated.
we
Let me say,
questioning, to
let's
his
say,
point,
just assume that I disagree with you about the
all the
history.
presidents who have
Let's assume
signed these
that I
into
think
law
I'll
knowing what was said?
grant you for this purpose that the decision of
Or
1789,
sign these
if you just took it in
agencies into
isolation, maybe
existence, I
not
should
as
say.
conclusive as Myers thought it was. I'll just grant you that for purposes of this question. But let's say that I think the liquidation argument throughout the 19th century shows that by the time of the end of the 19th century, up until we get to the ICC, and the emergence of what starts to look like the more modern independent agency, that the government has the better of the argument. But let's say that in 1887, after the ICC, and then after the FTC, and then after Humphreys, when there was more of the explosion of independent agencies, that let's just assume, again, for this purpose, that at that point, yes, you do have precedents like Humphreys. Humphreys clearly is a good case for you. Do you still lose? If I think as of 1887, it was liquidated, it was settled, but then we did have cases and congressional practices that veered from that unbroken line.
No, we don't lose. We don't lose on the merits, and we certainly don't lose on stare decisis. So on the merits, the doctrine of constitutional liquidation by historical practice absolutely can apply based on the last 150 years of history.
But counsel, if it had the first, I mean, in the assumptions that I've asked you to make, it was liquidated as of 1887. So you think liquidation can kind of get a new restart, like kickstart in 1887?
That is not just my view. That is the view of this court in cases like, I believe, NLRB, Canning, and Chiafalo. And I would also direct the court's attention to United States versus
Roe wasn't
Curtis Wright
settled
Export
law, it was
Corporation, where the
settled
court said,
precedent.
you have
but
150 years of historical
regardless.
practice. That's enough.
Okay.
Justice Jackson?
Really quickly on your exchange with Justice Gorsuch, your hesitancy to respond to his take care question, I'm wondering whether that has to do with the fact that prosecutorial discretion exists and that the idea can't be, I think, that the executive has to always enforce all the laws, right?
I think that's right, and the very authorities that petitioners cite in the reply brief actually stand for that proposition. In cases like United States v. Texas and the Heckler v. Cheney case, the court went out of its way to expressly and unambiguously affirm Congress's authority to regulate prosecutorial discretion by statute.
Agreed.
Let me ask you about
I told you he was fucking
Justice
up there.
Kagan's invitation to expound upon comparative risks. I don't know if we got back to that, but before you do that, let me just also focus in on Justice Kavanaugh's question about losing on the merits.
You need that guy back
and the
from the
extent
last
to
case
which
we watched.
The answer would be just
with
striking
law.
down the
What was
four-clause
his name? God damn it,
removal
I can't
protections.
remember.
I mean, I appreciate that,
awesome.
but doesn't that create pretty significant risks with respect to the missions of the various agencies? I mean, it's not just we don't have four-clause removal and the agency continues. That would then, I think, open the door for the president to come in, each new president, and clean house in terms of all of the individuals who are running that agency, notwithstanding their expertise and knowledge and experience and the things that they are doing to promote the mission of the agency. And presumably the president could install whoever he wanted in those positions, and that, I think, creates
It
risks.
may have been the
So why don't
Bondi
you
case.
talk
Hold
about
on, I'm trying to find his
the
name.
comparative risks of your formulation or understanding of the different
Rossellini from the Bondi
dynamics
case. We
and
need
what
him
the
back.
government says should happen in this situation?
Sure, there are real world risks that are palpable that we know can materialize very quickly if petitioners get their way. And think about it in terms of commissions like the Federal Elections Commission. Would anyone want those sensitive election-related determinations to be under the plenary
Okay, so this is an appeal to outcomes, and like I want y'all to understand that while obviously it's reasonable, appeal to outcomes will not work on the side of the court that doesn't already agree. Making an appeal to outcomes strongly contradicts with the sort of like textualist originalist perspective because they're not preoccupied with outcomes. They want to know why is it there?
We have
what
a
did
big
it say?
problem. We've been lobbying Congress, and Congress is just, to Justice Kavanaugh's earlier point, they're just not going along with
I
it.
agree with
They're
all
not
of
doing
y'all
right
that the
thing.
outcome is
Presidents are
important.
not even
It's
trying
just
to go to Congress to get these
not going to
Presidents
make
have
an
accepted
appeal.
That there could be both an understanding of Congress and the presidency that it is in the best interest of the American people to have certain kinds of issues handled by experts who, and I think you were in your colloquy with Justice Kagan, you identified the fact that these boards are not only experts, but they're also nonpartisan. So the seats are actually distributed in such a way that we are
they're appointed by presidents to ignore that there would be some idea of partisanship.
And actual
that's intellectually dishonest.
How these decisions
that's
are made.
That's not a fair claim.
Risk, I think, of allowing these kinds of decisions to be made by the president, of saying everybody can just be removed when I come in, is that we're going to get away from those very important policy considerations.
But I can agree with her to that point, that if we allow presidents to just do this, then we're going to see this rapidly shifting sort of economic change between conservative perspectives on economy,
the realities of the world that we live in, risks associated with extreme concentrations of power in the hands of one person.
Can you talk about the FTC? This is my final question. Why would Congress have thought it
Don't play though,
to make
because the minute Democrats get in, they're going to pull this
I think in large part because Congress had
I'll keep it a buck. I will call it exactly what it is. If Trump gets the power to do this, the minute the next Democrat steps in office, not only are they going to be loyalists, but they're going to have a completely different they're going to have completely different theories. I'm going to call it what it is. I can already see this coming.
All the different things that would constitute unfair methods of competition. And so what they wanted was an expert agency that could take on that task and that would be insulated from political pressure, not just emanating from the president, but emanating from Congress too. Congress is giving away its own power to some extent.
So your point is that they were doing something important for the interests of the American people, not with an effort to try to strip the executive of any authority or anything like that.
This is a good line though, because we're talking about the power of Congress, which is something I said I'm concerned about.
Absolutely, and
in
a lot
the background
of ways, they're giving
of
the
this
president
case
more power than he had before, because the president wouldn't have the authority to determine what are unfair methods of competition all on his own. And that's what will be the practical result of accepting petitioner's theory, that tomorrow you'll have a situation where the president can come in and unilaterally decide. This is a quintessentially lawmaking function. Unilaterally decide what constitutes an unfair method of competition, what constitutes an unfair trade practice. If that was going to be the law, why wouldn't Congress just reserve that power to itself?
Thank you.
That's a good question.
Thank you, counsel. Rebuttal, General Sauer.
Thank you, Mr. Chief Justice. Two quick points.
Hi,
on the sort of parade of horribles argument that's being made, I think it's very telling that Mr. Agarwal, one of the last things he said is that the FEC has to remain independent. But of course, the FEC does not have statutory removal restrictions. And under Braidwood, the president already has the power to remove the commissioners of the FEC. Therefore, the notion that like this is the end of the world, it's going to change the structure of our government. The lead counterexample that's given is one that's already been decided by this court's cases. Justice Barrett, regarding the question of historical liquidation, we think the case that you ought to look at is Powell against McCormick. It's very analogous to the sort of historical, what happened in the history here. In that case, Congress, from the time of the founding until the Reconstruction Congress after the Civil War, had interpreted the Constitution to not allow it to refuse to seat a member of Congress other than the reasons that are set forth explicitly in the Constitution, the Qualifications Clause. The Reconstruction Congress changed that and decided not to seat a couple of former members who had too close ties to the Confederacy. And after that, for the next 100 years or so, Congress then started exercising that power, not often, but intermittently exercising the power to refuse to seat other members. And this court said in Powell against McCormick, what is decisive there in that point of constitutional interpretation is the liquidation that occurred in the 19th century, not the subsequent, again, very lengthy tenure of practice of Congress refusing to do that. And therefore, it held that Congress lacked the power to refuse to seat the congressman in that case. We think that's very, very compelling here. I think it's very telling that in this particular case, early on, Mr. Agarwal said twice that it is within the realm of possibility that Congress could take, not sure how many, but a significant number of cabinet-level agencies and convert them into multi-member agency commissions outside the government's control. How many of them it could do is really a creature of not a question, a constitutional question on his view. It's a question of statutory accident. Are there conclusive and preclusive powers in the organic statute there? If there are, maybe they could be excised. And obviously the devil's in the details here, because if those conclusive and preclusive powers are fairly broad, as the colloquy about civil enforcement powers illustrates, if they're fairly broad, then basically we would win this case and virtually every other case, because almost all the agencies, cabinet level or independent agencies, are going to have civil enforcement powers in most cases and so forth. But if they're narrow,
but I'm going to go back to something we postulated earlier. Maybe you
executive branch outside the president's
if they're exercising some sort of conclusive, preclusive executive authority, maybe you carve that out.
That is the
and you don't
the court ought to consider,
take away the
for
cause
dramatically with what, for example, Madison said when he talked about the great principle of unity and responsibility, the chain of dependence that runs from the lowest to the middle grade to the highest to the president, and the president is accountable to the community, which is the voters.
Bullshit.
In short, Humphrey's executor is a decaying husk with bold pretensions. It has a powerful hold on the minds of some people within our constitutional system. It certainly seems
they're
to have a powerful
appointed
hold
every
on the minds
7
of
fucking
lower
years.
court
Like, this
decisions.
is
The
a
court should,
rotating cycle.
the lower courts and their decisions. The court should overrule Humphrey's executor
absolutely
explicitly and restore the separation of powers to our government.
Thank you, counsel. The case is submitted.
Okay, that was the only case for today. Does anybody have any questions? Law, if you want to come up, you're welcome to. It was a hot fucking mess. The attorney arguing for Slaughter was popping his Supreme Court cherry, for lack of a better term, on this case. And when asked, does a president have to enforce all the laws, by Gorsh, could not just definitively say yes. I don't think this is looking good. I'm gonna call it what it is. This is not looking good. Is Law still here? Yeah. If you have questions, just drop them. I think Barrett and Kavanaugh for sure their questions seem to be more like they wanted to kind of like maybe like narrow it a little bit, not quite wipe it out, but Alito, Thomas, and to a larger extent Gorsuch were very like, let's do this. Roberts is always kind of like, I don't know. I don't know where he's at. So just a lot of like, and then the liberal justices, Kagan, Sotomayor, Jackson were obviously very like, you could kind of see where they stood. It's, this is going to be fascinating. Tell me why. Oh, I don't vibe with Amy. I'll explain that. You did tell me you wanted me to explain why I like Amy Coney Barrett. So I don't agree with all the decisions she makes, like morally or things like that. Like I did not like the outcome of the Dobbs decision. However, I will say that she's been much more likely to like write in a partial concurrence, a partial dissent, where she thinks that the court is like, when the court kind of like goes off on their shit, like this happened in the immunity ruling. I really felt like she, hit the nail on the head. And I don't agree with the outcome of Dobbs, but Dobbs was also built on fundamental flaws, like that even Ruth Bader Ginsburg acknowledged. Like, it was just built on a bad argument. It could have been built on something better. And like, while I don't like the outcome of Dobbs, and certainly I live in Texas, it's a problem for me in my state, I'm more mad that Congress had 50 years and didn't do shit than I am at the Supreme Court for reading a shit argument and being like, that's not really what it is. That's just my hot take. I don't, she's not bestie, but I like her as a justice. Does anybody have any questions about this case? Law, if you want to come up, now's the time, Pookie Bear. Probably shut this down in a minute, but yeah, this is not gonna go well. I'll call it what it is. This is not gonna go well. I need to read it, Law. I'm gonna have to buy it. Yeah, I like her as a justice. I also think like she's one of those people that it's really kind of like fucked up. Like, I am not like her biggest fan, but I will also say that like I find that when her and Roberts are on this sort of outlier, they're, I would say they're more like, they want to sort of like preserve the integrity of the court than like lick Trump's balls. Like, I'll call it what it is. Some of the justices do that a bit. They're very big on like sort of preserving integrity, and I can see that with her. Oh, sorry, Law. I didn't see you, but somebody brought you up. Hi.
Hey, how's it going?
Good. How are you?
Good. I didn't hear the argument, so I don't have much to add, but I have a theory about the breakup of the Supreme Court. It's not as quite, 6-3 conservative liberal as you might think. And I think where, this is going to be a narrow decision, probably 5-4, which way I couldn't tell you. But you have the three liberal justices that are, they subscribe to a more flexible, with the context of modern times interpretation of the Constitution. Then you've got the textualists, the originalists with Thomas, Alito, and Gorsuch. But then Roberts is very much of the institutional vein. He's not one to shake up the court precedent as many as some of those more institutionalists, or I'm sorry, the more textualist judges might. And Barrett's and Kavanaugh fall into that bucket as well. So you kind of have 3, 3, and 3. And I think you're going to have the three, voting to uphold Humphrey's executor. But then Roberts will probably go along with upholding it, just doctrinally. I didn't hear the arguments, but I read the briefs. And then it really comes down to where Kavanaugh and Barrett are going to fall.
So I will be really, really honest, and you may have to go through and listen to the argument because there may be just something I didn't catch from Roberts. I could not clock Roberts. He asked kind of equal questions of Sauer and equal questions of Slaughter's attorney. I didn't feel a lot of lean there, but I usually don't with Roberts. Roberts is usually very quiet. Like, he doesn't talk a lot. So when he's talking during a case, I'm looking at what is he saying, who is he talking to, and like what questions is he asking. Barrett and Kavanaugh, very much. Kavanaugh, I would say, probably going to lean maybe a little bit more with the Thomas Alito Gorsuch. Gorsuch was very actively like, you could tell he was just like, yeah, fuck this shit. Like, let's go for that.
Well, yeah, he's very much a like that you never had the authority to create an executive agency in the first place. You crossed the lines on that day.
See, and like for me, I don't know why in my head, like I was thinking it was going to be the opposite. I was thinking Kavanaugh was going to be the person that was going to be more Gorsuch in this situation, and Gorsuch was going to be the person asking more questions. But it was just my like sort of interpretation at the beginning. It kind of got a flip flop there. But Barrett and Kavanaugh seem to be like, well, maybe we can sort of tinker with Humphrey, but not exactly get rid of it, if that makes sense. Roberts, I don't know.
Yeah.
And then the other one.
Yeah, if there is a 5-4, for upholding it, it's probably going to be a narrowing rather than a pure affirmation.
Yeah, I don't know that they will be like gutting it, but I do think that they will maybe narrow this. That's my interpretation and sort of the lean that I got from just listening to the arguments. I could be wrong,
I usually I'll listen to them and then I'll go and read them, because sometimes when I read the transcript, I pick up things that I missed during the oral arguments.
I do better with the transcript, but like I will tell you, freaking Jackson and Kagan were killing it today in like the fact that they just gave no fucks, and they were like, oh, so you just want to give the president, the power to do whatever the fuck he wants, basically. Like, I mean, I know this, paraphrasing here, but like they were killing it. Like they did not care. They had no fucks left to give, and they were just like,
they've been on a warpath against this unitary executive theory and trying to poke holes in it. And I think, those questions like that are just as much for this as it is going to be for like birthright citizenship and things like that, because they're trying to build up they're trying to get the government on record saying, well, what are the limits of the executive authority? Are there any? And that will bear fruit in other subsequent cases.
Well, my bigger, and it's sort of like, maybe it's just my perception and me, but like a lot of sort of something I was seeing going on is that while they're saying like, this is just executive purview, this is their power, I get that, they're making that claim and that's their argument to make. A lot of it felt like to me that they're sort of questioning all around the authority of Congress. They're not making that argument like specifically, but they're just saying, we don't like that Congress can do all this. So we just,
Yeah, and it is a fair criticism. Like if you look at it, if you were to just read Articles 1, 2, and 3 and say, here are the powers, having a legislative branch that creates an agency that has executive oversight, with executive appointments, and then quasi-judicial enforcement activity, like that's a big Venn diagram that our Constitution in a pure reading shouldn't really tolerate.
Well, what bothered me is like, and I sort of like this proposal. Like they brought up the conclusive and preclusive, authority about 500 fucking times. I swear to God, if Gorsuch said it one more time, I was going to punch my screen. But anyway, they brought this up multiple times, and I sort of like, I liked one of the responses from the attorney arguing was that if they're exercising this sort of like authority that's like conclusive, preclusive, like executive authority, well, why wouldn't you just remove that instead of removing the protections from Congress, if that makes sense? And I sort of like the way that was crafted. Is it practical? Maybe not. But yeah, I can agree with you to some extent. It's a hodgepodge and it creates confusion. And whether you like Trump, hate Trump, that is sort of what this administration has been thriving on, is sort of that confusion and the overlap and sort of where can we poke holes in it.
Yeah, trying to point to the things that they don't think should ever have been taken away to the executive or are explicitly within the realm of the executive but haven't been recognized, and trying to push those boundaries and then limit the boundaries of the other branches into that executive authority.
I mean, like, I definitely can't say for sure, but I don't think this is going to go well for Slaughter. I'll say it like that. Maybe it will. I've been wrong before. I will be wrong again, but I just...
Once or twice.
What killed me was that this is the first case this attorney arguing for Slaughter has ever done in front of the Supreme Court. This was not the time for that. this was not the time. I want to see somebody who's been there 30 times. I don't know.
You definitely don't put your rookie who you just signed, who hasn't been to training camp, out on the field.
Well, apparently he clerked for Alito and Kavanaugh back when Kavanaugh was wherever he was before. Sorry, he did clerk for them, and then great. But again, this is just. It would not be what I would want to, like, for lack of a better term here, pop my cherry on. Arguing against John Sauer. I don't like Sauer, but he's a good attorney. Like, I'm not making the argument that he's a bad attorney. Like, it's just, that wouldn't have been.
Well, he's a good attorney for this court because he knows how to speak the language that's going to get him 5 votes.
Yeah. No, the
all right,
worst...
I got to run, Cass. I'm sure you did lovely. I'll go back and watch it later.
All right, no worries. Love y'all. Bye. I'm gonna sign off too, guys. Y'all have a good one. I love everybody, and y'all have a great day. If you have any questions, hit me with the DM, and I will try to get you an answer. Love you. Bye.